Hello, everybody. I had to get my coffee. I'm sorry. I'm very, very sorry. I had to get coffee. And it's too hot to drink it yet. Hi, Nana Laura. Hi, Tammy. How you doing, sweet sis? Hello, Shane. Who else we got in here tonight? Hello, crazy old lady. I love you. I love you bunches. So, I have actually, it's a long docket, but it's actually a really fun one. This judge, he doesn't hold back, like, at all. I sent Emily and Tammy a clip yesterday. I was like, mic drop. Like, this guy is cranky old and I love him. Absolutely love him. You know how I feel about cranky old men. They've got my heart. Hello, Filipinos. Good to see you, sweetie. I love you so much. I'm so happy to have you in my life. So, hi, Foxtrot. How you doing, Foxtrot? Good to see you. Oh my gosh, you guys. So Billy decided to run outside tonight. I was taking Ava potty. It was 36 degrees out, and the sky was spitting slushies. Seriously. Like, I had little dishes out for water for the squirrels, and they were filled with slush. It was coming down as slush. And it was coming down hard. And I opened the door up, and I knew Ava wasn't going to run off, and nobody's walking their dogs in it, but she had to go potty. So I opened the door, and all of a sudden I see this gray and white streak just go out and start running down the ramp, and I'm thinking, if you must, you know. And so I'm standing there waiting for Ava, and all of a sudden that gray streak comes flying back up the ramp, and it does a dive into this ferret hutch that I have outside. And it's just mostly storage right now, but yeah, he just dove into it because it's covered with a tarp. And I'm laughing at him, and he knows it. So he's going, wow. I open the door. I don't think I've ever seen that chunky boy move so fast. Oh, I'm sorry you've been having one of those days, Foxtrot. Well, this is a good docket to just lay down and relax to. I've cut out all of the super long spaces, and I've made it so, you know, you can just listen to the cases and relax and laugh when the judge tells these people the truth about life, which they very desperately need. Here, I gotta move your comment. She knows when I look over at her. You've got my blanket all messed up. You messed my blanket all messed. Hi. Are you being lazy? You being lazy? Pretending like those back legs don't work? You knocking my stuff all over there, girl. What are you doing? What you doing? You want a treat, don't ya? Okay. She's like, Mama, that means you gotta move. I gotta move. We gotta get this situated so you can get the treats. Okay. But you know the drill. You gotta come say hi. You gotta come tell everybody about your day. How was your day? How was your day? Huh? Hold on. Wait. Can I have my boob back? Thank you. Gentle. There you go. Lip smacking, huh? It must be good. Must be good. We hear your lip smacking. Yeah. Philip Heels asked for you. You're so pretty. And Billy's up here too. You want a chicken biscuit? Chicken biscuit. Billy, what you doing, buds? What you doing, buddy? You're creeping me out there, man. Hold on, I gotta chat see here. Can someone explain my cat, please? This is how he sits a lot. Hi, buddy. Oh, he is something else. No! Oh my God! Okay. Billy is obsessed with garlic. Garlic is toxic to cats. 5 times more toxic than onions, and they're pretty darn toxic. I made garlic bread one day, and when it was all done, I left the pan out, didn't throw it in the sink right away. And I come back and he's licking it. For one, he's obsessed with butter. It's his favorite food. And now he loves garlic. I'm going to make fresh garlic bread. I love garlic. I ain't got nobody to kiss. So I was chopping the garlic up and I had it sitting here because, I love this thing. I can just sit here and go like that. And he's trying to get the lid off. It will kill you. When I was cutting the clove up, I have 3 of them in a little mesh bag. And so I'd gotten one out and the other 2 were in the little mesh bag. And it's one of those that like cinches itself kind of thing. And he was trying to get him out. He was fighting the bag. I love you too much to let you eat garlic, you little shit. Oh. Shane, butter is food. Margarine is not. Margarine was actually originally developed because they wanted a cheap turkey feed and they found it killed the turkeys. And they had these like barrels of this turkey feed that they couldn't feed to turkeys. And they decided, well, this is the same texture as butter. Let's add some coloring and make it look like butter. Humans are much bigger than turkeys and they'll eat a whole lot less of it if they think it's butter. So that's what we're eating when we eat margarine. Failed turkey feed. So. That's my fat butt. That's Billy. Yeah, look at, here he goes again. Oh, now he moved. Oh man, he was doing his sit again. When I come inside from when he's waiting at the door, he's sitting like that inside the door, and I'll open up the door, and he'll be sitting with his one leg up, and he'll literally just flop over backwards. It's the funniest thing. I've got to record it. I have got to record it. I've got to catch him doing it. You guys would laugh your butts off. It does. And the other thing with margarine too. So if you take food, take actual real food out to a farm, put it in a barn. You're going to have bugs in it. It's going to mold. It's going to rot, whatever, you know. That's what food does. Take margarine. Put it in the barn in the corner. Come back a week later, a year later. It will look exactly the same. And it will not have been touched by bugs. That's when you know it's really bad. Yep. Absolutely. Oh my gosh, Philip. I've done this court stuff for way too long. I didn't see the name, but I thought it said for meth and me today. And I'm like, who's talking about that in my chat? Well, I'm glad you and Beth had a wonderful meal. Oh. You ever do that? Like you're driving along and you see a sign or something and you're like, that could not have said that. I gotta go around the block. There was in Baraboo, I was coming down 8th Street and there was a business and their sign said REMS. And the letters were staggered. They were stared. But it looked like penis. I'm not kidding you. The font and the way that they were staggered, I had to go around the block and like stop. And I'm like, what does that say and why? It took me a minute to figure it out. I got it figured out. Man, some businesses need to check their font. Yeah. Night shift with April at Gmail. That's my YouTubey one. Right? Yeah. Yep. It's like, how did my brain go there? Freud. Freudian slip. My brain lives in a Freudian slip and slide. Yep. All right, guys. I am going to... Yeah. It happens. Someone will get a wonderful email from you. Hi, Queen Purple. Good to see you, sweetie. Hi, Ardo. I love you. I miss you. I miss you so much, Ardo. And yes, lick the like button. What? Were you just sitting in Discord? I even went on the executive chat and texted you and said I posted it. We really weren't trying to exclude you, I promise. Yeah, now we're going to have to call her. I'm sorry. I'm so sorry. Well, you're here now. The really good stuff hasn't started yet. It's just been me joking with the chat. That's all. You know, the fun stuff. I know. Aw. Thank you, Foxtrot. Yep. All right, guys. I'm going to put the clip on. I don't know. I catch this docket a lot. I download it almost every day. I don't ever actually look at it. And I just decided, oh, I'll check it out, blah, 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 blah. I love the judge. I love him.
Record on the court's sentencing docket on Friday, March 1st. First matter of the court will call is file 23-10218. People say Mr. versus Kevin McIntyre. Attorney Swisher, see you here. Present. Mr. McIntyre's case is on the court's docket for sentencing here today on a charge of operating on intoxicating third offense. And Attorney Swisher is here present on behalf of Attorney McIntyre and Attorney Ronning. You handling this?
Yes, sir.
People? All right. I have received and reviewed the pre-sentence investigation report and the sentencing information report that was prepared by Agent Browning. I had a chance to review that. Also received the updated community corrections status report from Krista Smith, the community corrections manager. I've reviewed that as well. Did you get a chance to receive all of that information? Review that, Attorney Ronning?
We've had a chance to review the report. We have no objections or corrections, Your Honor.
And Attorney Swisher, did you get a chance to review that and go over with your client?
We have reviewed those reports and we have no additions or corrections. Thank you.
And is that correct, Mr. McIntyre? You had a chance to go over the report?
Yes, Your Honor.
And you have no additions or corrections as well? Okay. Before sentencing then, Mr. McIntyre, I'm going to take comments from the people. Attorney Ronning, I'm going to hear then from your attorney, Mr. Swisher, on your behalf, and then if you choose to make a statement on your own behalf, I'll give you that opportunity as well. Attorney Ronning.
Your Honor, as this was pursuant to a plea agreement, we do agree with the recommendation of the probation department.
All right. Attorney Swisher.
Your Honor, we have reviewed the pre-sentence investigation report and find it to be complete. Mr. McIntyre is a hard-working individual. He works at a local company here in Cassopolis that builds sky booths for these large stadiums, and he's been working there for quite a few years. Very hard worker. He's been coping with an alcohol issue after going through a very tough divorce. I indicated to him that he needs a support team. He's advised that Woodlands has an open door policy, the counselor there, where he can, get any support needed. And so, he's given a good chance here by the court. He appreciates it, and hopefully he'll be able to fulfill his end of the bargain. Thank you.
Mr. McIntyre, is there anything that you want to say on your own behalf?
No, Your Honor.
Well, Mr. McIntyre, in this matter, on August 12th of last year, approximately 4:15 p.m., you were involved in a personal injury accident. Single accident, your vehicle went down an embankment off Shirt Street, Penn Township. When deputies arrived, your vehicle was being towed from the ditch by True's Towing, and deputy made contact with you. You appeared intoxicated. The officer asked if you had been drinking, and you indicated you had just one drink, approximately 11 a.m. with a friend. You agreed to take field sobriety tests, which you failed, and you were given a preliminary breath test, and the results were .242. So obviously you had a lot more than just one drink with a friend. At which point, after the PVT, you were placed under arrest. In the vehicle, the officer did find several empty alcohol bottles and an unopened Smirnoff bottle, a bag of marijuana, and some marijuana edibles. You're 55 years old. This is your first felony conviction, and that's based on the fact that you do have the two prior operating while intoxicated convictions in your history. Concerning to the court, however, is that you did have your last OWI conviction in 2001, and that was also for a high blood alcohol content. So you obviously have, as your attorney pointed out, have had a drinking problem, and it's kind of escalated in the last few years. I hope you do something to take that care of. I look at your report. You have an associate's degree. You have a decent job. It looks like you've held since 1986. So you're lucky you didn't kill or seriously injure yourself. And the other thing, and I'm sure you've talked about this with Attorney Swisher, and you're lucky you didn't injure or kill somebody else, because you'd probably be going to prison today. So that's where you're at if you don't get that drinking and driving under control. If you're involved in an accident and seriously injure somebody, just the guidelines on those kinds of matters would be prison related. So that's where you have yourself. So the prosecutor agreed to a delayed sentencing in this matter to give you the opportunity to keep this felony conviction off your record. Also have the charge reduced to the operating while intoxicated second offense, which is a misdemeanor. You need to thank the prosecutor for that. You need to thank your attorney for his advocacy on your behalf as well, because you're given a great opportunity here. I can assure you that if you're back before this court for drinking and driving related offense, you won't get this same opportunity. And if we see you back, even if it's not for an accident, you go to prison, the likelihood is you'd receive some substantial jail time if we see you back. So I hope you take all that into consideration and make sure that you get this issue under control. I'm going to have to assume as well, from the prosecutor's standpoint, that they probably looked at your record and said, basically, for most of your life, you've been a pretty good citizen. You've worked hard. You've done what you're supposed to. However, your drinking and driving has to stop today, plain and simple. Because if you violate the terms of your delayed sentencing, what will happen is you'll come back before this court on those felony charges, and then the court will seriously consider imposing a long jail sentence based on your guidelines. And if the court did that, at your age, you could lose your job that you've held for 37 years, and at your age, it may be hard to get back out and find another job. So it's real important that you take all those things into consideration, and as your attorney indicated, get yourself engaged in services to make sure that this doesn't happen, okay? So what I'm going to do is I'm going to adopt the recommendation, plea agreement in this matter, and on the count one charge of operating while intoxicated, third offense, the court will formally accept your plea for the record pursuant to Michigan Compiled Law 771.1. I'm going to delay your sentence for a period of 11 months. That'll give you the opportunity to prove your eligibility for leniency when we do come back for sentencing. During the term of your delay, I'm going to order that you undergo a substance abuse assessment and our mental health assessment as directed by your agent. You complete any recommended programs or services directed by your probation agent. You'll also be subject to random alcohol drug screens just to ensure that there aren't any issues. I'm going to require that you report to your probation agent or supervising agent as directed. You comply with all written and verbal orders, be subject to standard terms and conditions of probation, and that you pay a supervision fee of $330. Since there is an agreement to reduce the charge to a misdemeanor, should you comply with your delayed sentencing agreement, I'm not going to impose the mandatory minimum 30 days. Today, understand that on an operating while intoxicated third offense conviction, there is a mandatory jail sentence. However, because the prosecutor is giving you the opportunity to delay your sentencing, I'm not formally going to sentence you in this matter for 11 months. So your sentencing is delayed. So I'm going to not impose that at 30 days. The reality is, and so you understand, is if you violate probation, you're probably going to get more than 30 days, because that's just a mandatory minimum that the court looks at by statute. If you violate the terms and conditions, then you will again come back for sentencing. I will require, however, that you, since I'm not imposing that mandatory minimum jail sentence, that you spend the first 120 days of your probation on the Michigan Department of Corrections Scram tether. That'll monitor whether or not you are consuming any alcohol. We'll order that you serve 2 days in the Cass County Jail with credit for 2 days already served. In addition, there will be a $68 minimum state cost assessed, crime victim rights assessment of $130. Court will impose a fine of $1,000 and court costs of $500, which the court deems reasonable based on the average cost of prosecuting a criminal case here in Cass County. I'm also going to order to comply with DNA testing and pay the associated $60 fee. I will advise you, Mr. McIntyre, you do have the right to appeal your sentence or conviction here today. To do so, you can file an application for leave to appeal. If you could not afford an attorney on your own behalf and wish to have an attorney assist you in an appeal, you could request the appointment of a court-appointed attorney, and I'm going to have you, the deputies provide you with notice of your appellate right to review. I'll have you initial that, showing that you've received that. You'll receive 2 copies. If you did wish to appeal, you could submit one to the court, return one of those to the court within 42 days of today's date, and I would review that for the appointment of an attorney. You're also free, if you choose and are able to afford an attorney and want to do appeal, you could retain counsel as well to assist you in that regard. With that, I want to wish you good luck. I want you to make sure that you follow through with the services. If you did request or did want to request counsel for an appeal, you need to make sure you return one of those forms to the court within 42 days, okay? Anything further from the people?
Nothing further, Your Honor.
Attorney Swisher, anything further?
Nothing, thank you, Your Honor.
Mr. McIntyre, what I want you to do then, immediately following sentencing, I want you to go down to the clerk's office, set up a payment schedule on your fines and costs, and then I want you to also contact the probation department. You're in town here, probably be just easy enough if you went over there to the courthouse. I think you probably went over there when you talked to them on your pre-sentence investigation. Go over there, set up an appointment to go over your terms and conditions of probation with your probation agent, okay? All right.
Thank you, Judge.
Good luck, Mr. McIntyre, and hopefully we don't see you back, okay?
So that was, I mean, he told him like it is. That was a very mild one. The judge was just bluntly honest. I love him.
Let me give you, Attorney Swisher, we do have a date for your sentencing, for your delayed sentencing. That'll be on Friday, January 31st, and we can go ahead and provide a copy to you of your client. Yes. Thank you. Yep. We'll go ahead and adjourn in your case then, Mr. McIntyre. Next matter the court will call. We'll call file 23-10047FH, People State of Michigan versus Ashley Luster. And you're Ashley Marie Luster, is that correct?
Hi.
Are you Ashley Luster? And
I'm Attorney Hutchins.
Hutchins, on behalf of Ms. Luster. Have a seat.
Thank you, Your Honor.
Attorney Ronnie, you handling this as well on behalf of people? All right. Ms. Luster, your case is on the court's docket for sentencing on a charge of possession of methamphetamine. The court did receive and review the pre-sentence investigation report and the sentencing information report that was prepared by Agent Larry Browning, and I had a chance to review that. We'll make use of the report in making a decision here today. So let me just check. Attorney Ronning, did you get a chance to review that information?
I've had a chance to review the information and have no objections or corrections.
All right, and Attorney Hutchins, did you get a chance to review the information as well, go over it with your client?
We did get the opportunity to review it, Your Honor. We have no adjustments, deletions, or corrections.
All right. And is that correct, Ms. Luster, you had a chance to review the information?
Yes, sir.
And did you have any additions or corrections?
Yes, sir.
I will give you the opportunity to make a statement later if you choose. First, I'll hear from the prosecutor in reference to sentencing here, then we'll hear from your attorney, Mary Hutchins, and then we'll give you that opportunity to make a statement. Attorney Ronning.
Your Honor, as this was a result of a plea agreement, we agree with the recommendation of the probation department.
All right. Attorney Hutchins, any comments on behalf of your client?
Yes, Your Honor, thank you. I've gotten the opportunity to get to know Ms. Lister over the past 8 months or so. She entered a plea almost 6 months ago, and she has been in counseling for the past few months.
So it's still at Riverwood?
Yes. She has not used any illicit substances during the time that I've gotten to know her. We would ask the court to go for a shorter period of probation, as she's been on bond for quite some time. I believe the offense actually occurred, if I remember correctly, in January of 2023. And so she's doing incredibly well. She's had a job for well over a year. She's got stable housing. She's a mom. She's a single mom, and so she's working full-time, taking care of kids full-time, and I think a long period of probation would be more than, would not be appropriate in this case, Your Honor. I think a short period of probation is appropriate, and I'm confident she will not have any violations and that she will get the benefit of the bargain.
Well, I guess my question is, the agreement was for a delayed sentencing and then a reduction at the end of the delay to the use?
It is, Your Honor.
And
It
so-
is. And so unless I'm mistaken, I believe the request would be that the delay would be a little shorter than normal because of her counseling and behavior while she's been out on bond. And Ms. Hutchins did bring that to my attention prior to sentencing, so I was aware she was going to request it, and we would leave that to the discretion of the court. The biggest concern we have, obviously, is that she's able to remain clean and remain in counseling, and if she's able to do those things, then she should get the benefit of that agreement. In terms of the timing of that delayed sentencing, we leave it to your discretion.
All right. Thank you. Anything further, Attorney
And
Hutchins?
honestly, Your Honor, you could test her today and she would be completely clean. So,
I would hope so.
exactly, she's doing really well. And so I don't want probation to be a hindrance because I know it's meant to be a benefit and a help to the defendants to get their lives in order and life back on track. And she's already doing a lot of those things. So we would just ask the court to keep that in mind. Thank you.
All right. Ms. Luster, anything you want to say on your own behalf?
Yes, sir.
Okay. I'm always amazed when I see people at your age with children come in here for a serious substance such as methamphetamine. You know, you have the ability in your life to, and you're going to be a role model to your children. It's either positive or negative. And it's pretty hard to ask children to...
That's what I was most worried about.
Yeah, it's pretty hard to ask children, you know, grow up, be good, go to college, amount to something.
Exactly.
When a parent is not doing the same thing.
Correct.
And so you're gonna find out, and the statistics will show that kids are gonna, if you're in trouble, in jail, prison, and things of that nature, about 80% of the time, so are the kids. So it's something, if you care about your children, obviously, and I'm sure you do, that you need to get these things under control. I never understand why people start. When I look at your record, you know, you've got a very minor record in the past, and you just wonder why that happens. You know why, and you need to address that. You have been in Riverwood, so I'll just keep that up, obviously, because you know, the impact you're going to have on your life and your children's life is going to be substantial if you don't get the problem under control. In this specific case, Ms. Lester, on January 16th of last year, about 8:30, Michigan State Police conducted a traffic stop in Milton Township because the vehicle you were driving, I had a Mazda S6, had a plate that was actually affixed to it for a Chevy Trailblazer. When the trooper made contact, you also did not have a driver's license, and you had your 2 young daughters in the vehicle with you. In an inventory search of the vehicle, trooper found a glasses case that contained a meth pipe and a baggie that contained meth residue. You were arrested, and your sister had to come to the scene to get your children. So just think of the impact that that has on kids too, and they're with you, and realize you could be anywhere. Something happens like this, and you know the impact it has on your children. You're 38 years old. This is your first felony conviction, although you do have 2 prior misdemeanor convictions for substances, marijuana, and OWI, but they're quite a ways back in your history. So, like I said, I'm surprised when I see, you know, a serious substance abuse at this time. Time you completed possession of meth, there was an agreement by the prosecutor to recommend a delayed sentencing for 11 months. And if you complied with the terms of the delayed sentencing, the charges would be reduced to a misdemeanor use. And I'm gonna go along with that when I look at your record, but I think it's important that you look at the PSI, and I want to point out your comments. You state you want to create a stable life, a sense of normalcy for your children, and you want you and your children, to be happy and healthy physically, mentally, and emotionally. I hope you understand that's never going to happen with methamphetamine.
Oh, I understand.
It's never going to happen with any drug. So if that's what you truly want for you and your children, if you don't get a handle on that drug usage issue, the only normalcy your children are going to see is their mother periodically getting arrested and their aunt having to go and pick them up. And that's not something that any kid should have to deal with. Note, as your attorney, Ms. Hutchins, pointed out, you're currently engaged in programming at Riverwood. So I want you to sign any necessary releases and information so that your supervising agent can receive updates on your progress in counseling. I also know you have a high school diploma, you have a decent job, you have good work history. Those are all great things for your children to see and emulate. So please, for the sake of you and your children, be a positive role model in their lives.
Yes.
And not a negative one. And it looks like you're on the road to being a positive one. I hope we don't see you back or any other kids see that. You have a good foundation to pass on to your children. Okay? It's real easy to destroy that. You can do 100 great things in life, and if you do the one bad thing, that's what people remember. That's what your children remember. They remember mom getting arrested. You know, the other things they kind of get in the back of their head, but they don't think of them because they're good things.
Right.
But it's when those things happen that has the big impact on it. All right. So on the count 1 charge, possession of methamphetamine, the court will formally accept your plea for the record pursuant to Michigan Public Law 771.1. I'm going to delay your sentencing. I will reduce it from 11 months to 9 months. You've been engaged in counseling for a number of months here, and that gives you the ability to prove your eligibility for leniency. We actually will come back for sentencing, but during that time, you're going to report to a supervising agent as directed, comply with all written and verbal orders, be subject, again, to the terms and conditions outlined in the pre-sentence investigation report. I'm going to also order, it sounds like you've already done these things, you don't have to do them as long as you sign the release of information, but that you undergo a substance abuse and mental health assessment as directed by your agent following your recommended course of treatment, including an MRT program. We'll urge you to submit to random drug screens as well at the request of your agent. We'll urge you to serve 2 days in Cass County Jail with credit for 2 days already served. You'll pay $68 in minimum state costs, a crime victim rights assessment of $130, a fine of $500, court costs of $500, which the court deems reasonable based on the average cost of prosecuting the case here in the county. And I will urge you to comply with DNA testing and pay the associated $60 fee. Hopefully we'll see you back in 9 months. We can have this matter reduced to a misdemeanor. One thing, if you do well on probation, the court can come back as well and look at sentencing you, and may very well turn around and continue to do well. Potentially consider a 7411 even disposition based on her performance. But and I think you need to understand, you can discuss that with your attorney. We can come back and under the use, if we come back and sentence you, we can sentencing under section 7411.
Your Honor, while I don't necessarily agree that that may or may not be appropriate in this case, I believe there is a marijuana conviction on the record.
There's nothing that prohibits on a second conviction. It's been a while ago, it was for a misdemeanor, so
Yes.
we'll look at that
Okay.
in the future. It's just something, so do well on probation. I'm not saying it's something that the court will do, but it's something the court could look at, which gives you the ability to actually potentially have the matter off your record totally. Doesn't mean it's not, if you came back before court.
Right.
We see those records, but it may not be in a public record.
Okay.
Your Honor, would you need a formal motion from my office?
No, I think we can review that, we can
Okay.
look at it, we'll give you, obviously, when we're back in court to allocute, you can go ahead and do that, and, but it's just when I looked at it, I thought, well, maybe we have one other option here, to be as an added incentive for you. If you stick around just a minute, I'm gonna assume that, Ms. Haley will have a date for us to come back.
All right, thank you, Your Honor.
Thank you.
Let me advise you, do have the right to appeal your sentence or conviction as well. Looks like you already did that. Take care of that. And what I want you to do, contact the probation department here in town here.
Okay.
And you know where the old court,
Mhm.
just stop in there, check in with them, set up an appointment to go over your terms and conditions of probation. Also go down to the clerk's office here before you leave, set up a payment schedule
Okay.
on these fines and costs that have been assessed, all right?
Okay.
Attorney Ronnie, anything further?
Nothing further, Your Honor, thank you.
Attorney Hutchins?
Nothing further, Your Honor, thank you.
Thank
Ms.
you.
Lester, do you have any questions for the court?
I don't.
I want you to stick around, like I said, we should get the date for you, so you'll know when you need to come back.
Okay, thank you.
Attorney Hoag, are you ready?
Yes, sir.
This judge's biggest pet peeve is drugs and kids. Parents not being involved in their kids' lives because of drugs or alcohol. That will set this judge off. That's foreshadowing.
We have Mr. Hicks.
He's in the county jail, Your
All
Honor.
right. Is the jail? Okay, the jail's not on, we can contact them. Why don't we take Attorney Kardotsky, I see you back there. Are you ready?
Yes.
Why don't you go ahead and just have a seat.
Good
Have a
for
seat
talk,
back,
Your
and when they get Mr. Hicks on, we can go ahead and get you going. Are you Mr. Smith?
Yes, Your Honor.
We'll go on record in file 23-10194 F8, People State of Michigan versus Matthew Ray Smith. And Mr. Smith is here in court represented by his attorney, Robert Kardotsky, and again, from the prosecutor's office, Aiden Chessie is going to be allocating on behalf of the people. This matter is on the court's docket for sentencing. I did receive and review the pre-sentence investigation report and the sentencing information report that was prepared by Agent Browning, and Attorney Chessie, on behalf of the prosecutor's office, did you get a chance to review the information and go over that?
Yes, I have, and no additions or subtractions.
All right. Yeah, Attorney Kardotsky, you had a chance to review that, go over it with Mr. Smith?
Your Honor, did receive a copy of the report, provide Mr. Smith a copy, had an opportunity to go over it. First correction probably isn't overly important, but on the basic information report, it says his religion is Odinism. He doesn't even know what that is, so I'm pretty sure he doesn't practice it.
What is it?
Odinism.
What page are you on?
First page of the basic information report. I skimmed right over it and didn't think anything of it, but
Oh, okay. So we'll go ahead and just cross that off in total.
and then first correction would be OV 12 is marked as 1 for the dismissal of the larceny in the building. I believe that under light, that would be the same, just a different way of committing the breaking and entering and taking the items.
Although isn't the larceny separate? You only have to have the intent to commit breaking and entering. You only have the intent to steal, not necessarily the theft, and the larceny itself is a separate offense. I'm not sure how light treats that. Obviously, with a robbery, having an armed robbery and robbery, an unarmed, there's a robbery that is required. I'm not sure if,
You'd still have the larceny, or
Pardon?
you'd have the
no, but
intent.
in a
both.
breaking and entering, you can break in and not steal anything.
Mhm.
It's your intent. You might get caught in the building and never steal. It's the intent, and I think with the larceny.
But
requires-
for the larceny in the building, you would have had to have the intent when you're breaking and entering, or breaking in, or going into, you'd had to have the intent to take it while you're in that building.
Yeah, but you wouldn't have to break.
Correct.
There are separate elements, and so I don't know,
But that would be the
how-
lesser, the LID would be the lesser of the two.
Is it a necessary lesser included, or it's not? So, I mean, I understand this, I understand under light that, which positions, I don't know if, there's anything, specifically that deals with that. You might be correct, I know that, again, I know the distinctions and whether something is necessarily included or cognate lesser included, so, Attorney Trainer, any, position from the people?
We believe that OB 12 was scored correctly, Your Honor.
Okay. I think it's scored correctly. I think that light, because there is a separate element, I think it does create a situation where you can be convicted of both, even independently, so I don't think they're necessarily a situation. So I'll go ahead and keep OB 12 scored at 1. I'll note your objection for the record for appellate purposes.
Next objection would be on OB 13. I believe it would be more properly scored at 5 points instead of 10. All three of the cited offenses are all property, and under OB 13 for 5 was part of a pattern of 3.
10 requires
property.
offenses against a person.
Yes.
And I think it requires the initial offense as well to be, OB 13 takes into account the sentencing offense itself. And obviously, 10 is if the offense was part of a pattern which includes crimes against a person or property. And so 10 does indicate person or property. 5, I believe, is, as you indicated, is 3 or more crimes against property, because this is a property crime.
Yes.
The others are property crime. Any position from the people?
We will leave it to the court's discretion, Your Honor.
Okay. Attorney Kardashian, I'm gonna agree with you. I think OB 13 should be properly scored at 5 points. We'll make that adjustment for the record. Any other,
That would be it on the corrections, Your Honor, and I believe that would change the OBs to 7 and then make these guidelines 10 to 23.
change it to OB level 1 as opposed to 1938, 10 to 23. Okay, court will make those changes. Anything further than Attorney Kardashian on the?
No additional corrections, Your Honor.
Okay. And Mr. Smith, then you had a chance to go over the reports with your attorney?
Yes.
Were there any additions or corrections that you wanted to make?
Nothing besides what he said.
All right. I will give you a chance to make a statement on your own behalf if you choose. First, I'm going to hear from Attorney Chastity on behalf of the prosecutor's office. We're going to hear from Attorney Kardotsky, and then this will give you the opportunity if you want to make a statement. Go ahead.
Thank you. Pursuant to the plea agreement, we support the recommendations of the probation office.
All right, thank you. Attorney Kardotsky.
Thank you, Your Honor. Mr. Smith's been at Twin County since he did Twin County's requirements. It tells me he's got 8 days left. He's completed the employability skills, life skills, MRT, IOP at Woodlands. He's continuing to see Bob Weber bi-weekly. He also is looking for work, and I believe he's got him a job that's to start here roughly a week in Dowagiac. He's attending Celebrate Recovery weekly. He tells me, he was homeless and struggling with addiction before this got started. It appears that he's getting him back on his feet, and we'd ask the court to adopt the recommendation and agreement.
Thank you. Mr. Smith, anything you want to say on your own behalf?
As Kardatsky said, I've been at Twin County. I've been trying to do well. This is my second time with the program.
I was going to ask you, why are we here? Because you should have had those tools initially to turn to appropriate people. Obviously, even the people in the program you can turn to.
I did, Your Honor. but sometimes it's hard to reach out to other people, and sometimes you don't work on everything that you should have worked on the first time. The first time I basically put my head down, just did what they said and got through it. This time I've actually put an effort into it. I've been seeking more counseling, going over more things, been more open, because there were some things that I didn't realize I hadn't ever touched on before.
Yeah, and that's the thing, I tell people when you're in these programs is to, get in the programs and do as hard a work as you can. If you try to do as little work as possible, and that happens, you're not the only person that does that. If you try to do as little as possible to get through, you'll be back. That's the truth of it.
It is, I'm proof of that. It's harder when you try to put in the real work. And I'm learning that this time. It's definitely a different program.
But if you can think about it, it's harder to be back in court looking at going to prison when you look at it at the end. So which is truly easier? Is it easier? It's like going to school. Is it harder to work hard at school, or is it easier to steal something and go to jail? I mean, when you look at what's the hard part, to get where you want to go, maybe the studying and the working hard is really easier when you look at what the consequence of the bad behavior is. So. Well, Mr. Smith, in this matter, you were involved, it looks like, in a series of breaking and enterings in Cass County back in 2023, 2 of which occurred at the same residence on California Road in Silver Creek Township, the residence of Judy and Jared Stillwell. And I guess I should find out from the prosecutor in this, were the victims here, or did they want to make any statement?
No, they are not, Your Honor.
Okay. Now, the first occurrence at their home was on March 5th, while the Stillwells, I guess, were just moving into the residence. The second one happened again on the 21st, a few weeks later. And a trail camera caught a picture of one of the subjects. Later, the Cass County Sheriff's Department received a tip that a Raymond Goff was dropping you off to commit the robberies and then would come back and pick you up when you were finished. And that tip told the police that the most recent burglary was on California Road. So Detective Cook ran your name, Mr. Goff's name, through the online leads, found a pawn report in the name of a Raymond Goff, and Ms. Stillwell was able to identify some of the jewelry that was pawned at the Worldwide Pawn in South Bend as hers. On April 15th, then, Detective Cook spoke with Mr. Goff, who gave you up, told the detectives he had taken you down to pawn the jewelry, and that he only pawned it for you because you said you didn't have your ID on you. Look, you're 44 years old, and the prosecutor agreed to let you participate in the ATC program, and you need to appreciate the prosecutor's office here as well as Attorney Kardowski, because going through a program a second time, that's something that the prosecutor has to agree to. So, take this opportunity and use it wisely. I can assure you, I don't think I've ever seen him agree to a third time. And the court also has to agree to it. And so it's, I don't know if I've ever agreed to a third time either. So it's important that you take it seriously. Now, you have been in the program since you entered your plea on October 9th, and I think you've been in Twin County since October 13th. And by all the reports, with the exception of one violation, you've done pretty well. I am concerned for 2 reasons when I look at your report. We've kind of mentioned on them. First, was that you previously completed the program back in 2021, but eventually had your probation revoked in that matter, and that was after the completion of ATC. We revoked your probation and you spent a year in jail. Second, since that case, you committed 2 more felonies, one for burglary tool, possession of burglary tools, one for possession of meth, and that's in addition to this matter. So when I look at those, and I realize some of them may have occurred previously, I know that's kind of what you're shaking your head.
Yes.
But when I looked at this behavior happened, I have to assume that was because of probably drugs and things that had been maybe involved in your background. Last time when you violated probation, you got a year in jail. This time, stakes are higher. The reality is if you violate probation and fail either at ATC or your probation, you'll go to prison. That's probably, just the reality of the situation. I know you've been to prison before, so I don't want you to expect to receive any leniency. You know, sometimes the court looks, if someone's been there before, it's going, okay, I'm gonna maybe give them one more chance at a long jail sentence to avoid prison. But you've been there, I know in the past, you know what it's like, and that's really the reality of the situation. It sounds like you're doing real well, you've got your head on right, and I think it's, you know, it's, you mentioned you kind of put your head down, you do the work, and you don't open up. It's really not as hard to tell people what problems are. I think we think it's going to be harder, and once we do it and we deal with your case manager, the things, since they deal with it all the time, you go, that really wasn't as hard as I thought it was going to be.
Sometimes it's hard recognizing it in yourself.
Right, and so just put in the work. You're still young enough to have a decent life ahead of you, but you're getting at that point in life. I tell people that if you go to prison, you're going to get old in a hurry. You know, you're at that point where you still got probably 30, 40 years ahead of you. If you go to prison, you start getting old by the time you get out. So it makes it a lot harder. So I think when I look at the report, I see a lot of positives that you're putting in. And I hope you just, when something comes up in life, I tell people that's what life is. Life is not, it's easy to do well when life is good. You know, you're in Twin County, you're kind of in a controlled environment, you're doing things, you're looking to get a job, all these things are positive. It's easy to maintain a positive outlook. It's easy to do well. What's hard is when something bad happens, and it's gonna. It happens in everybody's life, my life, prosecutor's life, your attorney's life. Everybody, something bad happens. It's how do you control, who do you turn to when those things happen? You've got two choices. You can turn to drugs or crime, or you can turn to those people that can help you get out of it. Hopefully you're learning that, because if you turn to the crime or the drugs, you end up back in front of me, and you leave me basically with no option of saying, okay, based on your record, it's off to prison. That's not necessarily the best thing, it's not necessarily the thing that solves the problem, but that's the position you put yourself in the courts in.
No, that's part of why I asked for this program. I knew if I went to prison, I was gonna come back and have nothing and do the same thing again.
Oh, absolutely. And it's that vicious cycle. So make those changes, and you can have, like I said, you can have a decent life. So what I'm going to do on this count one charge of breaking and entering with intent will be the sentence court. You'll be placed on probation for a period of 3 years under the terms and conditions outlined in the pre-sentence investigation report. There will be a supervision fee assessed of $1,080, and that will be paid at the rate approved by your agent. As a term of your probation, you shall successfully complete the adult treatment court program, follow the terms of the participant agreement. You also shall successfully complete the Twin County Community Probation Center. And when are you due to be out of there?
Next Sunday.
Next Sunday. So you've done well, get out, and do you have housing lined up?
I'm gonna go to either the CR House or the Lester House in Dowagiac, and I have a job interview on Tuesday with American Coolers.
All right, so things are looking up. So
his job interview's on Tuesday, not on Monday. Maybe the interview's on Tuesday, but he starts the job on Monday.
you know, keep it, like I said, remember, something's gonna come along, and just make sure that you're in a good position to make sure that you can address those issues when they do. But also require you to submit to random drug screens, as at the direction of your agent, undergo any substance abuse or mental health assessments as directed by your agent. You may have done some of those things already as well. I would order you serve 80 days in the Cass County Jail with credit for 80 days already served. Pay $68 in minimum state cost, crime victim rights assessment of $130. Attorney fees in the amount of $350 to partially reimburse the cost of providing the legal assistance in this case, and I would order you to pay court costs of $500, which the court deems reasonable based on the average cost of prosecuting a case in the county. There was no restitution requested, is that correct? I didn't receive a report.
That is correct, Your Honor.
Okay. Court will not order any restitution then at this time, based on the fact there has been no request for such. I am going to provide, you have the deputy there provide you with notice of your appellate right to review. Mr. Smith, you do have the right to appeal your sentence or conviction here today. You can do so by filing an application for leave to appeal. If you're financially unable to retain an attorney and want to have an attorney appointed to represent you in your appeal, you can make that request. Fill one of those forms out, which you'll receive completely return it to the court within 42 days of today's date, and the court would review that, and if you wanted to appeal, do that, appoint an attorney at your, for you if you chose. Okay? What I'm going to do then at this point in time to find out from Attorney Chasson anything further from the people.
Nothing else, Your Honor.
Attorney Kardashian, anything further?
Nothing further, Your Honor.
Mr. Smith, anything further from the court?
Thank you, Your Honor.
All right. Well, look in the mirror, think yourself, and really realize that this is probably the last opportunity to get your life going on the straight and narrow. All right. And I tell people, society doesn't ask you to do anything more than we expect of ourselves. I'm on probation every day. I don't break. There's things I can and cannot do in my life. That's what we ask you to do. And so realize that when you're involved in the programs, it's not, we want to get you thinking in the right way. It's that criminal addictive thinking, and I'm sure you'll be in those classes.
Oh, yeah.
But we don't ask you to do anything different than we do. I'm on probation every day of my life. So is Attorney Kardashian. I keep eye on him all the time, make sure he's okay. So it's just we live by the same rules that we expect you to live by. I'm going to go ahead and remand you back to complete Twin County and to ATC programs in the direction of your supervision and probation ATC staff. I don't know, are you headed back to Twin County today? You might want to stop at the courthouse on the way back to Twin County just to check, just to set up an appointment. Have you met with a probation agent other than the pre-sentence investigation? No. Okay. Why don't you stop at the court, the building is, the courthouse there at the corner and at those.
The old one? Yes.
Go in there and at least set up an appointment to have the supervising agent, to talk to supervising agent. And then before you leave the courthouse, just go down to the clerk's office, give them your background information. You'll need to make some payment arrangements on your fines and costs. I realize you're not able to do that right now, but you can give them the information, some contact information, and then when you do get your employment, make sure you just check with the clerk's office and get those arrangements set up, okay? All right. Any other questions you have, Mr. Smith?
No, Your Honor.
Okay. Good luck, and I hope I don't see you back here again. And again, you really appreciate what Attorney Kardashian's done for you. Truly appreciate the prosecutor's office. Realize that prosecutors, judges aren't always here to just hit you over the head with this. We're here to hopefully get you back on the right track in life. We want people in the community that treat people the way that you want to be treated. Think of how you'd feel if you came home, your house is broken into, all your stuff's taken. You'd be in here telling me, I want them hung at the highest tree. So just treat people the way you expect to be treated as well. Okay? Good luck, sir. We'll see you. Hopefully, we won't see you back. You'll be meeting with Judge Renfro, I
Yes.
think. So hopefully she can take care of you, all right?
All right, thank you.
Yeah, we're going to adjourn.
And Your Honor, Agent Leith here, I'll be reaching out to him at Twin County.
Okay, so he doesn't need to stop at the courthouse?
That is correct, Your Honor.
Okay, you can just go back to Twin County, then Agent Leith will meet with you there at
All right,
Twin County.
thank you.
Yep. All right, are you Mr. Hicks?
Yeah, this judge is definitely dealing out life advice to all of these people. And Shelly, babes, I'm so happy to hear that you feel the love and the inclusivity of this group, and that you miss us when we're not together. That's so sweet. And that's what this group is. We really are, we're here for each other. And the best part is that it's not just the lives. It's not just being in the chat together. We also have the Discord. And, Emily and Shane and Tammy, and Philip Heels, they all run the movie nights. And we get together for that. And we get together in the comments section after the videos, after the lives. I try to get in there and respond to as many people as I can. We really are family. I absolutely love every one of you. I feel like we're all such good friends. I know so much about all of you, and you know way too much about me. And Shane, thank you so much for the Cash App Super Chat. I really appreciate it. I do. That means a lot to me, and it really helps me. I'm still recovering from the 2 weeks of back and forth to Madison and you know, everyday meals on the road kind of thing. Foxtrot's gonna have to tell me his secret for how you do that. Oh yeah, we bonded over our medical traumas. Oh, speaking of which, I got my stitches out on my foot today. Yay, that was great. I still have to wear the surgical boot shoe thing that I'm in for another week, but I can now take it off when I sleep, and I can take a shower without duct taping a garbage bag to my leg. Y'all don't know how happy that makes me. Because, yeah, that wasn't fun. That wasn't fun. Duct taping the garbage bag to my leg and then having to hang my leg out of the tub while leaning all the way back against the back of the shower wall because I couldn't put all of my weight on just my right foot. So I had to try to put some of the weight on my back and then like angle the shower head towards the back wall so that it hits me and doesn't fly out the curtain that has to stay partially open because my foot's out. Ooh. Let's just say that was not my favorite 2 weeks. Oh, you guys are just the greatest. Yes, I know. Yay. All right, I believe the next case is the one where the judge really lays it down. It's either this one or the one after it, but the judge is not happy with one of the upcoming defendants.
Yes, sir.
All right, Attorney Ho. We'll go on record and file 23-10252F8, People of the State of Michigan versus Jack Curtis Hicks. Mr. Hicks is here in court via Zoom from the jail. Mr. Hogue, your attorney, is here in the courtroom on your behalf, Mr. Hicks. And who's handling this man? Attorney Chastity then is here on behalf of the people as well. Mr. Hicks, you do have the right to be here in person if you choose. If you are okay with it, we can proceed with sentencing via Zoom with you from the jail. Do you have any objection to the court proceeding via Zoom?
No, sir.
Okay. Attorney Hogue, then on behalf of your client, do you have any objections proceeding with via Zoom with your client?
None at this time, Your Honor. Thank you.
All right. For purposes of the sentencing here, Mr. Hicks is here on a charge of possession of less than 25 grams cocaine, or heroin, I'm not sure. I think we're heroin here. And I did receive and review the pre-sentence investigation report and the sentencing information report prepared by Agent Small. And Attorney Chastity, did you get a chance to review that information?
I have, Your Honor, and there is no additions or subtractions.
And Attorney Hogue.
Your Honor, only one small correction. My client indicates he's only done one prison sentence. It does indicate that he had 2 prior convictions that resulted in prison, but he's indicating only one.
Okay, I'm showing one back in 2012, which was a revocation of probation on a breaking and entering. It looks like he was sent to prison then and then showed a discharge from parole in August, so I'm assuming that that's the one that he's talking
Yes.
about?
Yes, Your Honor.
I see a 2015 case. It showed a 2 to 7.5. Showed he was sentenced on 7/17 and that he was actually paroled on May 31st. And he's which one of those is he indicating that that's now?
I believe it's the second one, Your Honor, that is indicated. Mr. Hicks, can you provide a little more?
I believe it's the 2012 one. I didn't go to prison there. The 2015 one is went to prison.
Your Honor, when looking,
Okay, just a second. I did pull up Michigan Attorney. So which one, Mr. Hicks, did you say you didn't go to prison on?
It was the concealed weapon, 2015, 2 to 7.5.
And you're saying you did go to prison?
No, that's when I went to prison.
Oh, okay, the 2 to 7, and then the 2012 one you're indicating, it does show that he was, it shows a discharge reason, probation violator kind of new sentence. So it looks like what happened, he was discharged 2015 when he was sent, he was discharged 7/17 of 15 when he was sent to prison on the new charge. So that would be correct. When I look at Otis, it looks like that, so they're showing that he went to prison, but that case was actually closed.
And that's what the people have just shared with me as well, Your Honor, that it looks like that he had one prison sentence for 2 different files. So from his perspective, it's only been 1 prison sentence, but technically it's actually 2 cases that had him in prison. So I understand. Mr. Hicks, do you understand what's currently going on?
Yes.
Okay.
You've only actually served 1 prison term, not there on 2 different matters.
Okay.
And that's consistent with what they're showing, because that 1 case is closed now. All right, with that then, we'll make that note. Any other additions or corrections?
Not this time, Your Honor.
I think I totaled them up a couple of times. I only showed 19 prior misdemeanors. And I think the reason for that is I think they might have counted the juvenile matters as misdemeanors, because he had the juvenile matters on there.
I think so.
But it doesn't change the scoring because of the number, but I'll just change the prior record to 19 misdemeanors because there were the juvenile convictions on there. With that then, Mr. Hicks, did you have a chance to go over the report with your attorney?
Yes, Your Honor.
Were there any other additions or corrections you wanted to bring to the court's attention other than what Attorney Hogue brought up?
No, Your Honor.
All right. I'll hear comments then from Attorney Chassie, then we'll hear from Attorney Hogue on your behalf. I'll give you a chance to make a statement then as well if you choose, Mr. Hicks. Attorney Chassie.
thank you. Pursuant to the plea agreement, the people are supporting the recommendations by the probation office, Your Honor.
All right. Attorney Hogue, any comments on behalf of Mr. Hicks?
All right. Just a few things, Your Honor. I think one thing, and I'm going to talk a little bit on the scoring, but I'm not arguing the scoring at this point. We acknowledge the scoring. Mr. Hicks on this date, when he had the interaction with the reason what led to his arrest, he initially had identified himself as a different individual, and I understand the concerns that can cause during investigations. But once things were very clear to Mr. Hicks what was going to happen, that he took responsibility. He said, yes, those were my drugs, that I knew those were there. And he even acknowledges, even to this day, that he has a drug problem. I think if you look at his history, and I think you can do this to almost any defendant that sits up here, you can kind of identify really where that issue had occurred. And I think Mr. Hicks might have started around 2012 or maybe a little earlier. It doesn't excuse a lot of his juvenile past, but I think what does explain a lot of this is people, places, and things. I think Mr. Hicks right now associates with the wrong people, he's engaging in the wrong activities, and he has the wrong mindset. And he even acknowledges that. He's had a term in prison, he doesn't want to go back. He wants to move forward with his life, and he really wants to put this drug issue behind him, because our discussions were really about is what is his next steps. He does have a good skill set. He's able to obtain decent employment through his construction trade, but until he can operate as an individual without drugs in his life, I think that worrying about making money should be on the back burner right now. We've talked about what Twin Counties means for him. We talked about what the Switzer Shore program will mean, and also talked about what would happen if he's violated. I know that you're going to touch on some of that, and hopefully you adopt the recommendations per the pursuant of the plea agreement. But I think at this time, and I even touched on to the piece that right now his guidelines are 5 to 23. So today he could be going to prison, and he knows that. And even touched on to the point of, look, it's either you get help now, or you go to prison, or you're going to die from your use. And we know what heroin has done to our community. We know what it's going to continuously do to our people until we get the education out there about what we should be doing when an individual starts down that track. And I know we have a lot of people working towards that, but right now I want Mr. Hicks to really worry about his own sobriety moving forward. And I hope the court gives Mr. Hicks the ability to at least attempt to get those skill sets. Thank you, Your Honor.
Yeah, before I turn to you, Mr. Hicks, I want to turn, Ms. Smith, I see you on there. Are there holds out of Berrien, St. Joe, and Van Buren? I know there are outstanding matters pending in those counties.
Good morning, Your Honor. Yes, that is correct. He has 3 holds in our system for Berrien for a probation violation, St. Joe County for a failure to appear, and Van Buren County in front of the court warrant.
Okay. Have you had any contact with them as to what their positions are? I mean, obviously we could put him in a program and give him that opportunity. It doesn't prevent them from returning him to prison. Do we know whether or not there's been any contact with any of the other counties?
I am not aware. Maybe Agent Leith or the PSI writer may have that information. Okay. I'm not certain.
Agent Leith, are you still on?
I am, Your Honor.
Have there been any contact with Berrien, St. Joe, or Van Buren? I mean, I looked, one's a child support case, one's an R&O, and I don't know what the PV is for. I would suspect with the R&O and the child support, they probably wouldn't object to swift and sure, but I don't know what the underlying probation matter is dealing with.
Yes, Your Honor, I can't speak for Van Buren County. I did talk with his agent in Berrien County, and it sounds like they're on board with that, and we're going to be asking for revocation and local time for that probation violation.
So it appears then that that at least at this point in time, the swift and sure is an option for him.
Sounds like it, Your Honor.
Okay, all right, thank you.
And just a little bit of clarity, I believe his pending charge right now in the report indicated that I think it was unlawful driving away or unlawful use of a motor vehicle, I think is the reason for his current pending violation.
All right, Mr. Hicks, is there anything that you want to say on your own behalf?
Yes, I realize drugs been an issue in my life for quite some years now, and I realize it's having to grow up. My children are out there without a father, and that kills me. I just hope the courts give me a chance to get my life back together and be a productive person.
Well, tell me why it takes you sitting in an orange jumpsuit in a jail to finally be concerned with your children. I hear it all the time. Everybody comes into court and says, oh, I love my children. I want to be there for my children. Why does it take being locked up to be there for your children? Most people make their children a priority in their life without having to be in jail in an orange jumpsuit. So tell me, it's easy for people to say that to me, and I hate it. I hate when people come into court and try to use their kids as an excuse as to why I should give you a program. I'm not adverse to it, but why do you
No.
wait this long?
It's, me and my ex, we broke up, a year ago, and, really that was probably the beginning of my downfall. I was doing pretty good up until, we broke up, and she took my kids and she left, and then I started doing bad, and, you know, I realized, I isolated myself away from my family and my kids, and she gave me all the opportunities I needed to, get myself together. I didn't. I started using drugs, and
Yeah, you
now
know,
I'm here.
you know, Mr. Hicks, when I look at your report, this is your, 11th felony, and you've got 19 misdemeanors in your juvenile record. I mean, you've got, you know, you've got a substantial record here, so. Mr. Hicks, in this particular case, on November 2nd of last year, you were stopped in Marcellus for operating a Chevy Trailblazer without a license. You did give the officer a fake Oregon driver's license with the name of an Aaron Burley, but it was not a valid license. Your true identity was subsequently ascertained a short time later, and you did have the outstanding warrants. The police vehicle was searched, and with the consent of your passenger, a Melissa Paul, she indicated the vehicle was hers. Under your seat, the officer found a black box that contained 4 capped syringes, a vial of heroin, which you admitted was yours. You know, you've only been, you're 39 years old, you've been to prison in the past, as you've indicated, and you were released in 2019. And you do have the outstanding warrants in St. Joe, Van Buren, as well as Berrien County, which we've discussed here. There was an agreement at the time of your plea by the prosecutor that you could participate in Swift Insure program and the Twin County program. I think you definitely could use the program. I just question whether or not 2 things. When I look at your record, whether or not you're going to get yourself engaged, be able to change that criminal thinking. And again, I have no control over what the other counties do. It sounds like they may very well be on board. You know, so I'm wondering whether or not you're going to undertake the efforts, because it's work. You're going to have to change. When I look at your life, your whole life has been spent committing crimes, having that criminal thinking. And, you know, when I look and see that this is your 5th arrest since being discharged from parole in 2019, I have some real concerns. You're going to have to put some hard work in. And if you decide to try to do as little as possible to get through the program, you're not going to make it. If you seriously care about your kids, want to make a change in your life, again, you're at an age too where you can do that. You still have a lot of good years ahead of you. If you don't do it now, you'll end up going to prison, and again, I tell people, you're going to get old in a real quick hurry if you don't make the changes that you need to. I'll give you the opportunity to prove yourself, but if you're not serious and you violate your probations, your guidelines will more than likely see you going back to prison. And it's not, you know, it's not a threat. I know you've been there, you've done it. I know you probably can do it again, not that you want to do it, but it's going to be a lot of work. Sometimes people tell me prison is easier than doing the programs. Because in prison, they tell you when to go to bed, when to get up, when to eat, when to shower. You know, you get time to go in the yard. That's pretty easy, other than you can't leave the facility. So you're gonna have to decide, because it's gonna be hard work. I mean, a lot of things you're gonna have to change about your life. Do you want the program?
Yes, Your Honor, I do, and, I just want, you know, and I don't want to do this for anybody but myself. You know, I want the opportunity to change my life, you know. I'm no good for my children if I ain't no good for myself.
Well, the reality is, if you don't change your life, the reality is your children will probably end up in jail or prison. Because statistics are going to show that when parents end up in prison, jail, high percentage is that's the same thing that happens to their children. And that's because they don't have any other role model. they don't know how to be positive in life. So if you care about your kids, realize if your kids go to prison or jail, you can look in the mirror and blame yourself, because that's the reality of the situation. If they end up in prison, it's because you didn't change your life. So I'm going to give you that opportunity, but I hope you're serious about it. What I'm going to do, Mr. Hicks, on the count one charge, possession of heroin less than 25 grams, will be the sentence court. You're placed on probation for a period of 3 years under the terms and conditions outlined in the pre-sentence investigation report, or to pay a supervision fee of $1,080 at the rate approved by your agent. I'm going to order you enter and successfully complete the Swift and Sure Sanctions probation program, comply with all the requirements of any participant agreement. As a condition of your Swift and Sure probation, I'm going to also order you enter and successfully complete the Twin County Community Probation Center. You shall have substance abuse or mental health assessments directed by your agent, participate in all recommended services, including random drug screens. As a further condition, I'm going to order you to serve, what do we have here? 121 days in the Cass County Jail with credit for 121 days. Ms. Smith, do we have, or Agent Leaf, if we know, do we have any projected time for him to go to Twin County?
It's my understanding, Your Honor, with the holds, that he'll need to, that once he's released, he'll be released here and turned over to either Berrien, Van Buren, or St. Joe County to take care of those matters. We'll keep track of him and get him into Twin County when he is available from the other counties.
All right, I'll order your 121 with credit for 121. That means, Mr. Hicks, today what'll happen is you'll have served your sentence here in Cass, at least your initial sentence. Then the other counties can then come and pick you up and deal with the holds that they have on you. As part of this case, you'll also pay $68 in minimum state costs, a crime victim rights assessment of $130, attorney fees the amount of $350 to partially reimburse the cost of providing you legal assistance, court costs the amount of $500, which are deemed reasonable based on the average cost of prosecuting a case here in the county, or to pay a fine of $500. Again, there was no restitution requested, so none is ordered. What I want you to also realize, Mr. Hicks, is if you're going to be seeing me if you do get into the program and the other counties agree to it, you're going to be seeing me at least every month. So I keep track of you, and if that's any incentive to you to keep on the straight and narrow, realize that I conduct a review of the cases with the participants every month, so you'll have an opportunity to see me, and I'm going to be keeping track of you, all right?
Yes, sir.
All right. I'm going to advise you do have the right to appeal your sentence or conviction. I see the deputy there providing with your notice of appellate rights. If you wish to appeal, you can file an application for leave to appeal. If you wanted to appeal your sentence or conviction here today, and wanted to have an attorney appointed to represent you and could not afford one on your own, you could fill one of those forms out completely, return it to the court within 42 days of today's date. I would review that and appoint an attorney to represent you. I'm going to go ahead and remand you back to the custody of Cass County Sheriff pending your admission into the Twin County Community Probation Program. That'll be dependent on the holds from the other counties. I will, when you are done with the other counties, order that any release from jail, be it a Swift and Sure staff or Twin County Community Probation staff only. At some point, Mr. Hicks, once you get into the program, if you do, you'll need to contact our clerk's office and set up a payment arrangement on your fines and costs. Attorney Chastity, anything further from the people?
Nothing further, Your Honor.
Attorney Hogue?
Nothing else, Your Honor, thank you.
Mr. Hicks, do you have any questions for the court?
No, Your Honor.
All right. Good luck, sir, and hope you take the opportunity seriously, because the reality is with the extensive record that you have, this is probably the only opportunity that you're going to get to make those changes. So take it seriously, put in the hard work, and hopefully you can get this behind you, all right?
Thank you, Your Honor.
All right. We'll go ahead and adjourn then. Attorney.
Absolutely everything that judge said there is 100% true. Everything. And, you know, this guy's going to get to see this judge every month for quite a while. And I have a feeling if he messes up, this is the judge that's going to tell him, I'm not mad. I'm disappointed. Yeah. Absolutely, Shelly Babes. He does. Right down to talking about, how prison is easier than doing the programs. Absolutely. There are people who would rather be in prison because they call it institutionalized, where in prison they have their own towns, basically. That is their community. They know how to act in there. They don't know how to act out here. And the biggest part of it is that they can't take any kind of authority figure over them. Like it's a punch to their pride. And really that's the biggest part of it. It's a sense of arrogance and pride that you see in almost every convict. Everyone that I've ever met. And with drug addicts, almost every one of them that I've ever met, they have this sense of entitlement to them. They think they're justified in their actions, and they have this I'm going to get whatever I can kind of mentality. And they have to break that. And it's so hard to relearn all of those things to fit into society. It's, I hope he can get clean. And I hope he's serious about wanting to be a part of his child's life or his kids' life. I don't know how many he has. I heard that line from one of my exes. And he was the worst addict that I have ever met in my life. And I told him when he was, I want to be a part of my kid's life. I want to be a part of my kid's life. I told him, I'll put you through outpatient rehab. I was making really good money at the time. I'd been at my job for almost 7 years. And I was the top employee, not kidding you. I have an entire tote of awards to prove it. And I told him, I'll put you through outpatient rehab for 1 year. And he was stealing meds from people. He was seeing multiple doctors and getting multiple scripts. He was also filling the Suboxone. He was selling his, and then he'd be out of his and the Suboxone because he sold his. So then he'd go buy them back for more than what he sold them for. And all of this I found out too late, a little too late, I spent a year and about $8,000 to put him through outpatient rehab. And the next time I heard about this guy, my niece tells me that she overheard him in a gas station. And he was with a girl. And the girl was crying. And so my niece was listening because she heard the girl say his name and then say, "But you told me you'd get me a sandwich today. You said you had enough. Now I'm not going to get to eat again. You said it was only $1.99. It's $4.99. You don't have that." And the girl was just hysterical. And my niece said that they looked like they'd been on the street for a while. And it kind of broke my heart. It really did. Not for him. Screw him. for her, because I know the hell that she is going to be going through if she doesn't wise up. He had every opportunity to get clean, and he squandered it. And the whole BS line of I want to be in my kid's life, that's just a line that was thrown out there to hook me in. And it's sad because his kids suffer for it. All of their kids suffer for it. And then their kids end up in the same boat as them. I hate it. Absolutely hate it. Yeah, but you're not now, Salty. Well, you're recovered. There's a difference. Some people want the help. Some don't. It's a cycle. And not everybody is that strong. And not everybody has that mentality. I wish they did. I still firmly believe that the problem that we have is much less a drug addiction problem than it is a mental health problem. Be it trauma from a parent not being in your life because of their addictions, or assault, or whatever that you went through, whatever someone has gone through. I think that's what leads them to that path in the first place. But some are willing to accept the help that's out there. And God bless them. There's nothing I want more in the world than for people to get the help that they need. I'll put it this way. Like you mentioned that, that you worked your butt off, right? For years. What his mentality on it was standing on a street corner with a cardboard sign. And he got $200. Instead of putting that for rent or food, he went and sat outside of a motel room for 9 hours until the dude got done with his job and came back to his motel room. And then the dude charged him double for showing up unannounced. And he happily paid it, and he had no money then. That's that guy's mentality. Some people just suck. All right, I'm going to put the case back on.
Kardowski, do we have Mr. Murphy?
He should be in jail, Your Honor.
Okay, he's in jail as well?
He's on his way, Your Honor.
All right, we'll go on record and file 23-10195 FH, People State of Michigan versus Deontay LaShawn Murphy. Are you Mr. Murphy?
Yes, Your Honor.
All right, Mr. Murphy, your case is on my docket for sentencing here this morning. Your attorney, Mr. Kardowski, is present here in the courtroom on your behalf. You're present for sentencing via Zoom from the jail. You do have the right to be here in person if you want. I can, with your permission, proceed with sentencing today with you via Zoom. Is that okay with you, or did you want to be here in person?
You can presume, sir.
Okay. Any objection if we...
No objection, Your Honor.
All right. For purposes of the sentencing then, the court did review and receive from Agent Browning one of the sentencing reports and the pre-sentence investigation report from Agent Browning. I had a chance to review those reports. We'll make use of those reports in making a decision here today. Attorney Ronning, did you get a chance to review those reports?
I have had a chance to review the reports. I do have one objection to the offense variable scoring, Your Honor. Offense variable 9 is currently scored at 0. I believe that the factual information in the PSI would support a scoring of 10 points. There were 2 police officers involved in the resisting, obstructing, so there would be 2 victims placed in harm. The underlying charge for the CCW and the RNO were all completed at the same time. And so I think that the fact pattern supports 2 victims placed in harm or danger for scoring a 10. It would modify his guideline range to 10 to 23 months, would still leave our requested sentence within the guideline range, but we would ask that they be scored at 10 points.
And Attorney Kardowski.
We leave it to the court's discretion.
Okay, I think we do have 2 victims in this matter, so I will go ahead and score OV 9 at 10 points. That changes the OV level to 30?
I believe that's correct, John, yes. To a 10 to 23 guideline range by my calculation.
Yep, that would change it from a 7 to 23 to 10 to 23. We'll make that correction. Any other additions or corrections?
Nothing further, Your Honor.
And Attorney Kardowski, then, did you get a chance to review the report? Go over with Mr. Murphy.
Did receive a copy of the report, Your Honor. Had an opportunity to go over it with Mr. Murphy. First correction, I believe on the jail credit. I believe I came up with 221 days instead of 220. I believe there'd be 7 days for July, 31 for August, 30 for September, October 31, November 30, December 31, January 31, 29 for February, and then today. I added it up a couple times and I came up with 221 each time. I don't know if the probation didn't count leap year or for this year or what.
That's possible. Ms. Smith, we've got Attorney Kardowski said he came up with 221 days credit, thinking that maybe the leap year wasn't counted when they were calculating it. Are your records showing 220 or 221?
My records are showing 221 days, Your Honor.
Yeah, I think that's probably what happened. They probably, because they prepared the report a few weeks ago, just took 28 days for February and didn't throw the leap day in there. So we'll go ahead and make that change then to 221. Anything further?
Your Honor, the other objection would be on OV-19. I think it'd be more properly scored at 10 versus 15. I mean, you really just kind of tensed up, and then the officers ended up pushing him up against the wall and took him down. Just believe that'd be more appropriate at 10.
I scored OV-19. I looked at that and scored that at 10 myself. Attorney Ronning?
The fact pattern in this is kind of one of those in-betweens, and so we would not object if the court were to make that adjustment. I think either 10 or 15. So if the court does make the adjustment, we don't have any objection.
Yeah, I scored, when I looked at it, I had that scored at 10 myself, so we'll go ahead and make that change. Let me see whether or not that 25 drops, and I think it's 24, so I don't think it changed. I know
No.
it scored 10
It'd
and
still be 10 to
09,
23,
so
Your Honor.
just double check. Did you have any other additions or corrections?
No, Your Honor.
Yeah, it still keeps it at the 10 to 23. All right. Drops it to the low end of the level there. All right. Mr. Murphy, can you still hear me all right?
Yes, sir.
Did you get a chance then to talk about, go over the report with Attorney Kardowski?
Yes, sir.
Was there any information in the report that you saw needed to be changed or corrected other than what Attorney Kardowski pointed out?
No, sir.
Okay, I'm going to hear from Attorney Ronning on behalf of the prosecutor's office. I'll then hear from your attorney, Mr. Kardowski, and I'll give you a chance to make a statement if you choose, Mr. Murphy. Attorney Ronning.
Thank you, Your Honor. The situation was an incredibly dangerous situation. Mr. Murphy should be very grateful to the hard work of Mr. Kardowski in this case, because this is a case with the felony firearm associated with the resisting, obstructing, though Mr. Murphy would be going to prison for 2 years plus whatever his other sentence would be. In negotiating the case with Mr. Kardowski, there was an agreement that his sentence be capped at 1 year in jail, which would technically mean the court could do less. Based upon all the factors in this case, Your Honor, we would ask that the court sentence Mr. Murphy to 365 days in the county jail. We think that the maximum under the plea agreement is appropriate based upon the loaded weapon, the resisting, and the actions that led to this, which involves a young woman who managed to escape from the defendant and call for help. So with all those factors in mind, we agree with the recommendation of the probation department.
Thank you. Attorney Kardasky.
Your Honor, Mr. Murphy's been incarcerated since July 25th last year. He tells me he's been attending AA classes since he's been in the jail. He plans to move back up towards Holland when he gets released here. To his knowledge, he was the only person that got hurt when they pushed him up against the wall. Obviously, he knows that he only made things worse for himself when that occurred. It is a cap, Your Honor. Even with the slight change in the guidelines with good time credit, he ought to be really close to the minimum on that. He'd ask the court to consider time served.
Mr. Murphy, anything you want to say on your own behalf before the court proceeds with sentencing?
Yes, sir. I just wanted to say I learned a lot being in here. I learned my lesson, and I will not be getting into any more trouble, Your Honor. And that's it.
All right. Well, I hope that's true, Mr. Murphy. When I look at this case, on July 25th of last year, police in Dowagiac were called to the Family Dollar about 5:15 because your girlfriend, at the time, Jacqueline Bryant, said she was being held hostage by you. She said you'd gone across the street to McDonald's, you had a gun, and she was trying to get away because she believed she was in danger. She advised she had come up to Michigan from Georgia with you, and that you were physically abusive to her, and that you threatened to kill her when she wanted to return to Georgia. The officers then went across the street to escort you outside to talk with you. At that point, you attempted to flee. You were apprehended, eventually taken to the ground, and you had a loaded 9mm pistol on you with 1 round in the chamber, 18 rounds in the magazine. You denied making any threats as well to Miss Bryant, which when I look at your record, I'm not so sure that doesn't seem very credible. You're 29 years old, you already have 3 convictions for domestic violence and 1 for child cruelty on your record. So it looks like you have an anger problem. So when you say you've learned a lot while you're in jail, hopefully it's to get your anger under control. Because if you don't, you're going to just keep cycling back and you're going to be around before court's over and over. It looks like when I look at the report, you think it's okay to control women through the use of violence. And so I think that's something that you need to address, because those incidents, that's going to come back to haunt you over and over. It looks like Ms. Smith, when I look at his reports here, that he has currently 3 outstanding warrants, 1 in Kalamazoo, 1 in Berrien, and then he does have 1 in Georgia. Are there any holds on him?
Let me look, Your Honor. Don't believe so. Your Honor, there is a hold out of Buchanan County with a cash bond of $200. That's the only bond I see in our system as of right now. He's been in custody since July, so there may be other things that have popped up and are now in lien that were not noted over the time that he's been in custody.
Okay, I noticed looked like Kalamazoo County may have had a hold on him as well. Buchanan indicated a pickup within 100 miles. Looked like Kalamazoo also had one, but it said pickup within 50. I would think that would include Cass. But you're not showing, that's a one from last July. You're not showing that hold?
I don't see it in our system. It doesn't mean it's not there or not in lien. It just may not have hit our system when they run his history prior to release, prior to his release date. Those warrants may pop.
Yeah, it doesn't look like. I mean, it's a violation of Parker rules, so I don't think it's anything serious that they may, want him for. But all right. Mr. Murphy, as I indicated, you need to get your temper under control. when it comes to women, you're gonna spend a lot of time behind bars, and you've already been arrested a number of times for those reasons. And what I want to say to you is there may be a good reason that you have problems with women, Mr. Murphy, and you need to take a good long look in the mirror and figure out it might be you. And so, and that's why it's important that you make those changes in yourself. Because if you ever want to have a normal relationship with a woman, controlling them and doing those kinds of things is always going to just end up with you probably back before a court. Now, at the time of your plea, there was an agreement by the prosecutor that you be sentenced to a cap of 1 year. I can accept the agreement based on the fact that the recommendation falls within the calculated guidelines. And the prosecutor did dismiss the felony firearm charge in exchange for the agreed upon cap. I really don't see anything in your background to me that would justify anything less than the full year. However, when I look at the number of days you've served with the good time and the fact that there is a hold out of Berrien, I'm going to go ahead, I think, and agree with you, Attorney Kardowski, on the count 1 charge of carrying a concealed weapon and the count 2 charge of resisting obstructing. The sentence court, you served 221 days, Cass County Jail with credit for 221. Obviously, he's going to be receiving about 5, 7, 30, an additional 35. He's going to be receiving some good time credit. I'm going to go ahead and order to pay $68 minimum state costs on each count, crime victim rights assessment of $130, a fine of $500, court costs of $500 if the court deems reasonable based on the average cost of prosecuting a case here in the county. Attorney fees in the amount of $350 to partially reimburse the cost of providing you legal services in this matter, and I will order that any firearms seized shall be forfeited under the authority of Michigan Compound Law 750.239. There was no restitution request in this matter, so none is ordered. And what I'm going to do is advise you, Mr. Murphy, you do have the right to appeal your sentence or conviction. The deputy is going to provide you with notice of your appellate right to review there, have you initial that, receiving that information. If you do wish to appeal your sentence or conviction and wish to request an attorney be appointed to represent you, you can return that one of those forms within 42 days of today's date, completely filled out, and court will review that appointed attorney if you qualify. I'll go ahead and remand you back to custody of Cass County Sheriff pursuant to the hold out of Berrien County. And once you are released from jail, Mr. Murphy, you'll need to contact the clerk's office here in Cass County, make payment arrangements on your fines and costs. Anything further from the people?
Nothing further, Your Honor. Thank you.
Nothing
further, Your Honor.
Yes.
All right.
Mr. Murphy, do you have any questions for the court?
No, sir, I just thank you so much.
All right. Well, you're going to get out here today. You're going to have to get deal with Berrien County. What I'd advise you to do is, even if Kalamazoo doesn't have a hold on you based on the nature, I would contact them, because if you don't, sooner or later, that'll probably come back to haunt you. It doesn't look like it's a serious charge. It was for a violation of some park rules. So I would contact Kalamazoo, get that taken care of, because it's not that big a deal. But if you end up getting arrested somewhere and held on that warrant, if you contact them, you probably get that taken care of without having to worry about going to jail, okay?
Yes, sir.
All right, good luck, Mr. Murphy.
Thank you. Thank you, Mr. President.
Attorney Drake, then, we have both Mr. Myers, he's in custody. Do we have Mr. Patterson?
Correct. Mr. Myers is in custody. No, he's still there. And I've got Mr. Murray and Mr. Patterson.
Why don't we take Mr. Patterson, and we'll just have them when we'll have the jail then bring Murray up.
And I spoke with Mr. Myers. He was fine by doing sentencing by Zoom. So.
Okay. We'll go on record then and file 2010282FH, People State of Michigan versus Timothy Allen Patterson. This matter is on the court's docket for sentencing here today on 2 matters. That's for a probation violation sentencing, and then he's also here for sentencing in file 2210217FH. And Agent Leith, are you still on?
I am, Your Honor.
All right. I do have a report that was prepared by Agent Browning in reference to the new case, the 22-10217 FH, and that matter is on the docket for sentencing, and I did receive and review the pre-sentence investigation report and the PSIs on that and SIRs. Did you handle those, Attorney Ronnie? Did you get a chance to review the information?
Your Honor, I have had a chance to review the pre-sentence investigation report on the new file. I have no objections or corrections on the probation violation file. Would leave that to the discretion of the court and the probation department.
All right. Attorney Drake, did you receive your reports in Mr. Patterson's case from Agent Browning?
I did, Your Honor. I had an opportunity to review those. I did have an opportunity to provide a copy to Mr. Patterson. There's one just, small informational correction on the basic information report, the top sheet. It has his marital status listed as married. That is incorrect. He is currently divorced. But other than that, I have no additions or corrections. Right under his height and weight as marital status.
All right. All right. Other than did you get a chance to go over the report?
Yes, Your Honor.
Okay. Other than what Attorney Drake pointed out, do you have any additions or corrections?
No, Your Honor.
And you did have a chance to go over those reports?
Yes, sir.
All right. Before court makes a decision, then we're going to hear from Attorney Ronning. I guess what I'll do, since Agent Leith, why don't you give us your recommendations for the probation violation, and then then the parties can address that as well if they choose.
All right, thank you, Your Honor. Mr. Patterson was ordered a 3-year term of probation on June 4th of 2021 for possession of methamphetamine and 2 counts of possession of narcotic or cocaine less than 25 grams. He was further ordered to participate in the Adult Treatment Court program as part of the plea agreement and would receive no additional jail if completed successfully. While in ATC, Mr. Patterson was participating in programming that included EOP at Woodlands. Unfortunately, Mr. Patterson was expelled from the Adult Treatment Court program in September of 2021. He pled guilty to the PV for being expelled and was ordered to continue on probation and to serve a 30-day jail term with 2 days credit. However, that jail term was suspended to the end of the probation period. Mr. Patterson was then arrested in January of 2022 for drug possession in Cass County, which is related to the probation violation and what he was here for sentencing today. Mr. Patterson was initially arraigned on the PV warrant on July 18th of 2022, but was adjourned due to the pending underlying charges in Cass County. He was then arrested in St. Joseph County, Indiana on November 10th of 2022 and eventually pled guilty to possession of a syringe and sentenced to a 1-year jail term on February 15th of 2023. Based on the criminal convictions in St. Joseph County and Cass County, it is recommended that probation be revoked. And furthermore, considering the plea agreement and time already served in custody, no additional jail is being recommended per the plea agreement, and he should be entitled to 261 days jail credit for time served, Your Honor.
All right, I guess my question is that I know what the agreement was, but previously there was a 30-day sentence imposed to be served at the end of probation, and that's not been served. If we close his probation today, is your position that he doesn't need to serve that?
Your Honor, I'll leave that to the discretion of the court since he was in jail for that period of time at the time of the probation violation. So I'll let the court determine if that is appropriate for that 30 days or if the 30 days will be extended on this probation violation.
Okay, thank you. Attorney Ronning, then, any contacts on behalf of people?
In regards to the new criminal charges before today, Your Honor, we would agree with the recommendation of the probation department. The factors I think are pointed out in the probation department's recommendation narrative, in particular that he had served approximately his guideline range in Indiana while this case was pending, that he would not be getting any credit for due to the sentencing rules. And so based upon those factors, we do recognize that the guidelines do call for a 10-month minimum sentence, and we do recognize that, but based upon the age of the case and all those other factors and the plea agreement, we agree with the recommendation of probation.
Thank you. Attorney Drake.
Yes, Your Honor. I think that for the reasons laid out by the Department of Corrections and the plea agreement, that the recommendation both for the new charges and for the probation violations are appropriate. As the prosecutor was just indicating, during that time that Mr. Patterson was incarcerated in Indiana, he was technically still on bond here, so he cannot, under the statute, get credit for that time. But that does not mean that we have to ignore the fact that he was locked up for a period of roughly 9 months in Indiana. He has, once getting out of Indiana, was brought up here. He did enter a plea up until his recent injury that required ACL replacement surgery. He was gainfully employed. He has a pretty positive work history. And so I think that all of the signs and his actions indicate that the resolution pursuant to the plea agreement and the recommendations of the Department of Correction, both for the new charges and for the probation violations, are appropriate, and we'd ask the court to adopt them.
Thank you. Mr. Patterson, anything you want to say on your?
Yes, Your Honor. I realize in my past, I've had a problem with drugs, and that's obvious. I really never spent any time in jail up until the time that I did. And at first I was mad at everyone else, you know, but then it really sat me down, and I thought, you know, that I'm gonna be in here if I keep continuing to do what I'm doing. So that really made me change my outlook on things. And since I've been out, I'm due to have a baby boy in July, and I've also been talking to my work, and there's an opportunity for me to maybe go down and transfer to Florida. I'm just trying to have a family and move on with my life in a positive direction, Your Honor. Thank you.
Mr. Patterson, on January 5th of 2022, Officer Wass in Edgeburg stopped you because you ran a stop sign. In the center console of your vehicle, you had a nicotine container with a white residue, a razor, and a straw. Residue tested positive for oxycodone. There were several backpacks in the vehicle, which you said belonged to your cousin Donnie. Inside one, the officer found an ashtray with a white powdery residue, tested positive for meth. At the time of your arrest, you were on probation to this court on other drug charges stemming from an incident in August of 2020.
Yes, Your Honor.
On those charges, you were expelled from the adult treatment court program and continued on probation, given a 30-day sentence on October 18th of 2021 to be served at the end of your probation. As a result of your new charges, you pled to a probation violation in that file and are also set for sentencing on that matter. Time of your plea in this matter, the new matter, there was an agreement by the prosecutor you would serve no additional jail time in either of these matters. And that was based on the fact that you did spend 9 months, basically a year down in jail in Indiana. That was after you committed this offense here. He's 34 years old, Mr. Patterson. You're getting old enough to understand you're playing with fire when you use meth.
Yes, sir.
It's going to do you no good if you don't find a way to address your addiction. It's just a matter of time before you get arrested again. And with the last 2 convictions on your record now, which don't come into play in your current guidelines, your guidelines are going to be substantial prison guidelines in the future.
Yes, Your Honor.
So, you say you've got a new child coming?
Yes, Your Honor, I do.
And when's that?
June 28th.
June 28th? Because if you don't change your ways, you're going to miss a whole lot of your child's life.
I know, Your Honor.
First day of kindergarten, graduation.
I'm not doing that. I can't. I mean, I'm getting up there where I can't even, this is probably about the end where I'll be an old dad, you know what I mean?
Oh, absolutely. And again, you'll be a whole lot older dad if you go to prison.
Yes, sir.
You know, I was inclined to give you the additional 30 days, which was the original suspended sentence. When I look at the fact that you served your time, I'm not going to impose that, I believe. We'll just give you the 261 credit for 261 on that file 20-10282 on the probation violation. I will revoke your probation in that matter. In file in the file 22-10217 will be the sentence of court That served 12 days in Cass County Jail with credit for 12 days served. You pay $68 in minimum state cost. Crime victim rights assessment of $130. Attorney fees in the amount of $350 to partially reimburse the cost of providing legal assistance in this matter. Court costs in the amount of $500, which are deemed reasonable based on the average cost of prosecuting a case in the county, which pay a fine of $500. I will advise you, you do have the right to appeal your sentences or convictions here today. Mr. Patterson, have the deputy provide you with notice for your appellate right to review. If you do wish to appeal your sentence, you can file an application for leave to appeal. If you want an attorney appointed to represent you, you could make a request for an attorney within 42 days of today's date. Mr. Patterson, if I ever see you back in my court again,
Yes, no, sir, you will not see me back in your court again.
I will not forget the fact that I gave you an additional 30-day break. You'll serve that 30 days and a whole lot more.
Yeah.
And you talk to Mr. Drake will tell you, I don't forget somebody when I tell him that.
I highly doubt you do. Thank you, Your Honor.
All right. Anything further from the people?
Nothing further, Your Honor, thank you.
Nothing further, Your Honor.
All right. Mr. Patterson, anything further?
No, sir, thank you very much.
Good luck, and hopefully get your leg under control, you get your life in control, and I hope you're serious. And you were
I'm very
sitting-
serious.
You were sitting in here. People have children,
Yeah,
and you're
don't.
gonna be a big impact on that kid's life. Either change your life, or what's gonna happen is your child's gonna end up probably in front of me or some other judge. I'm a little old, probably your child won't be in front of me, but they're gonna be in front of another judge. And so you've got a big opportunity to be a positive role model. Your kid doesn't know anything about you yet. Doesn't know about your past.
It doesn't matter, you're right.
Move forward in life and be a good father for your child, okay?
Thank you, Your Honor.
If you do have issues that come up in life and you feel compelled to go back to drugs, two things I tell you. I tell people, put a locket around your neck with your kid's picture. Every time you reach for them drugs, look at your kid's picture and say, which is more important to me? If you still think you want to grab those drugs, make sure you have somebody in place, be it Woodlands, preacher, friend, whoever, that you can turn to make sure you don't do that. Because you know the first time you pick that up, you might as well just pull that chain off your neck and throw your kid away. Because the first time you pick up that methamphetamine,
It's locked together, it's over.
well, and you're not going to do what's best for your kid.
Yes, sir.
All right. We'll go ahead and adjourn then in this matter.
I actually think out of everyone that we have seen, I think that guy is going to be the most successful in his recovery. He really seems to get it. He said at the start of his hearing, he said, at first I blamed everybody else and I was mad at the world, blah, blah, blah. And then he realized it was him all along. And that's the point they need to get to. You know, they need to break down that wall of blaming everybody else. And, you know, it's all their fault that, I'm in this position. You know, the cops did me wrong. You know, they had no right to arrest me for those drugs that I had on me. They should never have searched in my bag. You know, all that blame. When really they have no one to be mad at but themselves. They put themselves in that position. You know, but I'm really proud of the accomplishments that this guy has made. And I really don't think that he's going to be in front of this judge again. Thank you. Oh my gosh, everybody. Now Becky D's getting in on the membership gifting. I don't want to call it a fight. Like, y'all are just competition. Y'all are taking turns. Oh my gosh. Oh, hi, Missy B. And crazy old lady, honey. I hope you sleep sweet, my love. I saw the message that you're fading. You're fading fast. Get lots of rest. so that you can be here tomorrow. I'm getting tired too, but I'll wake right back up. I just need to go get some hot coffee because what I've got in my cup, there's like that much left and it's cold. Oh my gosh, Becky, you did 10 of them? Thank you so much. There's been 16 individually gifted ones by Tammy and Shane. You guys are so great. Oh my God. And then Becky D gifted 10. I can't believe how awesome you guys are, for real. Paul, we got one again. Well, he is very active in the comments after the lives. He almost always goes in and says something. Sleep sweet, Missy B. We love you. Oh no, Filipinos. Did you have to crank the generator? Aww. Chadaskaram! Hi, sweetie. Good to see you. I left you a message in Clallam County today. Oh, Tammy. Thank you so much. Oh my gosh, you guys. Yes. Yes, we are going to have a little coffee break in a moment. You know, I don't mind it so much, but I definitely prefer hot. But I will drink it cold. I do not waste coffee. Don't get me wrong. It's ice cold. Well, room temperature cold, which is ice cold to me. And I don't care. It's coffee. It is coffee flavored coffee. And I'm gonna drink it. But I'm also going to go get some hot coffee flavored coffee. Are you talking about the Nicola Maxwell trick? So Nicola Maxwell taught us that if you gift one membership at a time, it is more likely to hit someone that is currently in the live, in the chat. And it always will pick those who are most active in talking in the chat. So, yep, Nicola Maxwell cracked that safe right open. Golly, she's such a gem. I love her. Let's talk about her like she's not in the chat. I know. I wish you could. Some lady in court. That's great. I love that. I thought that you did. Because you can't. Can you be a member without being subscribed? I don't know how that works. I'm sorry. I need more of it. I need more of it. Yeah, I love that trick. Oh, Chadaskadam, that's so cute. Well, you can tell sis I say hi. Hi, Chadaskadam, sis. I'm that some court lady. Yeah, I think so. It wouldn't make sense if you were able to be a member without being subscribed. Okay, guys. I need to get more coffee. My mouth is so stankin' dry. Ugh, I hate that. Yep, I need more hot coffee.
And I see, are you Mr. Myers?
Yes, sir.
All right. All right, we'll go on record and file 23-10227 People say Michigan versus Ryan Roger Myers. Mr. Myers is present for sentencing here today on the charge of possession of methamphetamine. Currently in the Cass County Jail here via Zoom. Your attorney, Mr. Drake, is present here in the courtroom for sentencing. Attorney Chassie, you're handling this on behalf of people?
Yes, Your Honor.
All right. I did receive and review the reports, SIR and the PSI that were prepared by Agent Cornwell. Attorney Chassie, did you get a chance to review that information?
Yes, I have, and there are no additions or subtractions, Your Honor.
All right. Attorney Drake, you get a chance to review that information as well?
I did, Your Honor. I had a chance to go over to the jail and go over the information with Mr. Myers, as well as provide him with a paper copy of the information, the recommendations. I have no additions or corrections to the report.
All right, Mr. Myers, did you get a chance to go over the reports with your attorney?
Yes, I did, sir.
I want to advise you do have the right to be here in person for sentencing. I can proceed with sentencing here via Zoom if you're okay with that. Is that okay with you, or did you want to be here in person?
No, sir, we can go ahead and proceed.
All right, no objection from you, Attorney Drake?
No, Your Honor. I discussed this matter with Mr. Myers yesterday, and he indicated that he was fine proceeding by Zoom then, as am I.
All right. And other than the information, you had a chance then to review the reports. Is that correct with Attorney Drake?
Yes, sir.
And you had no additions or corrections to those reports?
No, everything looks in order, sir.
Okay, I'm going to take comments then from Attorney Chassie on behalf of the prosecutor's office. I'll hear then from Attorney Drake on your behalf. I'll give you a chance, Mr. Myers, to make a statement if you choose. Attorney Chassie.
Thank you. Pursuant to the plea agreement, we do support the recommendations of the probation office. I would like to note, though, that the guidelines are prison, so I would take considerable seriousness in the adult treatment court program and doing all the programming that's required, because the guidelines are prison.
All right, and I'm sure Attorney Drake's going over that with Mr. Myers.
Well, I have, Your Honor. In fact, as the PSI reports, his probation officer down in Indiana indicates that she's going to be requesting that the Indiana courts execute that 9-year suspended sentence that he has. So that is certainly a monkey wrench in the plans here if they do go through with that. But of course, you know, that's her recommendation. We won't know what Indiana's going to do until he gets down there to resolve that matter. He indicated that he did have an arraignment via Zoom with the Indiana courts on the pending charges that were associated with the conduct that led to these charges. So he has initiated that process, but the probation violation that has the 9-year suspended sentence is still hanging over his head, so that'll be the next step. I did discuss with him.
Let me ask,
Yeah.
I can do one of two things.
Yeah.
And I realize the agreement was ATC, so we can revoke the plea and proceed here, or I can impose, I could tell you I'm gonna do a 3 to 10, and then indicate it can be served in a correctional facility. That would probably, he'd serve ours way long before he served theirs suspended. So I don't know, because in reality, it doesn't look like, because that's what I heard, that the ATC probably wasn't a reality. So does it make sense to just sentence him directly here, or even adjourn sentencing and see what they do? Because if they're gonna revoke him and impose the 9-year, it's not even worth doing ATC.
Obviously, I can't predict what Indiana will do. We only have the report from the probation officer. Mr. Myers and I had this exact conversation. I anticipated, this sort of, issue being the elephant in the room. There's a few factors that Mr. Myers has indicated makes him hopeful that maybe Indiana will give him the shot at this, treatment program.
So he would rather have us impose the treatment so that when he gets down
Right.
there, he could say, hey, Michigan has done this.
Right.
Are
It's
you
giving me
willing
this
maybe
opportunity.
to even extend my supervision in Indiana?
Correct.
With a second hammer over his head, possibly.
Right, a much bigger hammer, by the way.
Yes.
9 years swallows up the top end of his guidelines in this case, so it would be, almost, twice, if not, 2.5 times the sentence that he could get here. And he would like that opportunity. And then there's the other more practical reason why I think that we should proceed with sentencing here today is because if we don't, then we can't get him down to Indiana on the probation violation, because for whatever reason, they won't address that via Zoom, even though they arraigned him on the new charges via Zoom. So if we adjourned, that won't get us any closer to an answer as to what Indiana's doing. We went over both the pros and the cons in some detail the other day. Talking about just what you were, Your Honor, that if he were sentenced here today without ATC, the sentence in Indiana would swallow it up and the end result would be the same. But his position on that is that, and it's no secret, if you look at his prior record, if something doesn't change, he doesn't know what will, in the sense that prison isn't going to be that, change. Giving his record, I think that that's pretty insightful. He's not sure that he can make the changes without the help and structure of a program like Adult Treatment Court. So even though it would be easier for him to just get a sentence and go on, he would like to have that opportunity at Adult Treatment Court. And so, we would make that a request to you, Your Honor.
All right. Mr. Myers, anything you want to say in court?
I just being honest, I'm sure you've heard everything from excuses to, other people saying things. Honestly, I don't feel prison is the answer for me. I've been to prison multiple times and I just come out a worse person, I think. I've never had a shot at rehab or drug court, and all my charges stem from my drug use. I'd just like an opportunity to try and break the cycle and try to structure environment like this Adult Treatment Court.
All right. Well, Mr. Myers, in this matter, on September 13th, you fled into Michigan from Elkhart County Sheriff's Department. Time you were under their supervision for dealing methamphetamine, and you currently have a pending probation violation on that charge as a result of this stop. Elkhart authorities managed to stop you in Jefferson Township here in Cass County, and then the Michigan State Police arrived and assumed jurisdiction because you were in Michigan. Your vehicle was searched. Michigan State Police found in a door pocket a blowtorch lighter, a bag containing meth residue, and a meth pipe. the time of your plea, there was an agreement by the prosecutor that you could participate in the ATC program. And I've received an assessment and recommendation from Clarence James for that program. However, when it looks like the agent's not recommending ATC because of your pending probation violation, the other active warrant in Elkhart. The case you're currently on in Elkhart shows you were given a 19-year sentence in 2018 with the last 9 years on probation. So there is a possibility that they're going to send you back to prison on that violation of probation. I know you've been to prison on 4 separate occasions, all for drug-related felonies. You know, one would think at age 44, Mr. Myers, you might be getting old enough to start figuring out what the end result's going to be if you don't figure out how to get drugs out of your life. It's not a matter of if you'll get caught, it's just a matter of when. So, you know, that's what that cycle's been doing for you. You're going to spend a substantial amount of time behind bars. So either you know, your attorney indicated that you want the court to go ahead and follow through with the plea agreement and impose the ATC program. Is that correct?
Yes, sir.
Okay. Well, what I'll do is I'll go ahead and impose that. I'll go ahead and give you that opportunity. It was part of the plea agreement. Again, it may come to fruition or may not. If Elkhart obviously sends you to prison, you won't have that opportunity here, obviously, and you'll be unsuccessfully discharged from probation supervision here. But as your attorney pointed out, if Indiana does send you to prison, that would swallow up any sentence that I could impose under the guidelines here. So what I'm going to do is on the count 1 charge of possession of methamphetamine, it will be the sentence of the court. You'll be placed on probation for a period of 3 years under standard terms and conditions of probation, outlined in the pre-sentence investigation report. Supervision fee of $1,080, and also that you enter and successfully complete the adult treatment court program and follow any terms of any participant agreement. You also successfully complete the Twin County Community Probation Center, undergo substance abuse and or mental health assessments as they direct. I'll order you serve 171 days, Cass County Jail with credit for 171 days served, $68 in minimum state cost, crime victim rights assessment of $130, attorney fees the amount of $350 to partially reimburse the cost of providing you legal assistance. In this case, court costs of $500, which the court deems reasonable based on the average cost of prosecuting a case here in the county, or to pay a fine of $500. I will advise you do have the right to appeal your sentence to this court, Mr. Myers. You can do so by filing an application for leave to appeal. A deputy is going to provide you with notice of your appellate right to review there. If you did wish to appeal and couldn't afford an attorney, you could request the appointment of an attorney at public expense. I would review that if you submit that within 42 days of today's date, and if you qualify, would appoint an attorney to represent you at public expense. Attorney Chassie, anything further from the people?
Nothing further, Your Honor.
Attorney Drake?
Nothing further, Your Honor. Thank you.
All right. Mr. Myers, do you have any questions for the court?
No, sir. I just want to thank the court for the opportunity to take this time and put myself in the treatment.
Well, I don't know if Indiana will give you the opportunity. I'm sure that there'll be some contact from our treatment court professionals up here down there with Indiana. There's 2 things that you may want to think. If Indiana gives you this opportunity, they're probably not going to close their case. They probably would keep their case open. So if you violate the treatment court program here, if Indiana agrees to it, you're putting yourself in a position to not only, if you violate the program, to go into prison in Michigan, but then turning around and going to prison in Indiana. And because each of those would be a legitimate sentence being served, you may not get credit, so they may end up being consecutive. So realize that if you do all the talking in the world and convince an Indiana court to put you in a program here in Michigan, you may just be adding prison time on top of prison time if you don't take the opportunity seriously. So I hope you understand that and realize it's the last opportunity you're probably going to get before your retirement age at the bare minimum. So,
I understand that, that's why I asked this opportunity, and I appreciate the state of Michigan for giving me that opportunity, and I just hope in the end it follows listening.
all right, we'll go ahead and adjourn in this matter then.
That should be enough to scare that guy. That he's facing the 9 years in Indiana, as well as, what was it? They said half of that for this case. And by the way, Indiana, that's where my favorite Judge Ditton is from. Yeah, Judge Ditton is right up there with my Clallam County judge. They're both tops. You guys are so great. Thank you. That is so cool. And Becky D, thank you again. Again. I know you're trying to hit Shelly Babes with it. I don't know why it knocked hers off. She's been a member for 2 months. She's got the milestone. But for some reason, it knocked her off. I don't like that a bit. It's not fair. But YouTube loves messing with me. I know, Catherine Gaston. I am sorry. Yep, we're gonna finish this out. We'll finish this out. You guys can go to sleep. Go to sleep if you've gotta. I'm gonna keep running the docket. That way you can play it on Replay Crew.
That concludes our sentencing docket this morning. Why don't we take a
Your
real
Honor,
short break?
I actually had one more. I had Steve Murray, he's an AG case of child support, but I don't see, oh wait, there it is. AG Pappen is.
Do we have Mr. Murray?
Was that?
We give Mr. Murray?
Yeah, he's here.
Okay, Mr. Murray, okay. We'll go on record in file 23-10222FH. People say Michigan versus Stephen Alexander Murray. Mr. Murray is here for sentencing on a charge of felony non-support, and Attorney Drake is here on behalf of Mr. Murray. On behalf of the Attorney General's office, we've got, go ahead and have you state your appearance for the record, sir.
Yes, Your Honor. This is Craig Pappen, appearing for the people, Your Honor.
All right. This matter is on the court's docket for sentencing on felony non-support. I did receive and review the pre-sentence investigation report and sentencing information report prepared by Agent Cornwell. Did you receive that information from the agent, Attorney Pappen?
Yes, I have.
Any additions or corrections to the report?
Well, the first thing, Your Honor, I would like to point out is that per the plea agreement, if the defendant pays support as ordered, we would agree to a delay of sentence. My Michigan Child Support Enforcement System reporting dated yesterday indicates that Mr. Murray has not made any payments during the month of February, which makes this a situation where I would then, lacking any other proof or receipts that he made a payment late yesterday afternoon, we would object to a delay of sentence and ask that we proceed to normal sentencing.
Okay, I do show, at least the report says defendant has paid $1373 through February 15th, but that may be because a payment came, they just credited that through the 15th, which is the date the report was prepared. Are you showing anything? We had the original $1,800, I think, that was paid, which was the bond, and then they show,
yes.
My report shows an additional $1373.76 paid on arrearages.
Well, I see arrearages, or at least as current payments, and some applied for arrearages in December, January. Last payment I show is January 16th, 2024. I don't show any payments in February. And as a requirement of the plea agreement that he pays as the obligation comes up every month, and he keeps current with his, with that payment. He hasn't done that. He's currently ordered to pay $158 a month.
All right. Attorney Drake, I don't know what,
Well, Your Honor, Mr. Murray does, according to the report and according to his own report, have employment, and he has a withholding order through that employment. I don't know, when you're talking, if you had said he hasn't made any payments while we're waiting for sentencing, but we're just talking about 1 month when he's been making payments, I don't know if that's a function of not having credit yet for a payment that's come in through his withholding
accounting
order.
issues, maybe? You
What's
said
that? Yeah, I don't know, I mean,
you're currently employed, Mr. Murphy, and you have an income withholding order?
Yes.
And where is that at? Where are you employed?
Shawnee Specialties.
Okay. And how long have you been there?
Almost a year.
Okay, and when did the withholding order go into effect?
I can't tell you the exact date.
Okay. Has it been since you pled, or was that in place?
It was before that, yeah.
It was what?
It was before that.
Okay. Attorney Papini indicates he's under withholding order. I don't know if it's an accounting issue or not. I mean, I guess we can do two things. We can adjourn and try to sort that out. He indicates he's under withholding order and that he's been employed. So as to why the support obligation isn't being paid, I wouldn't know why, unless it's just maybe the employer holds it and only sends it in once a month. I don't know. I don't know how the income withholding order is set up, whether they're withholding weekly. They should, but I know sometimes employers send it in once a month or whatever, so I don't know if we've got that kind of issue. Obviously, if we do proceed with a delayed sentencing, if he's not making those payments at the time of obviously the delayed sentencing, he'd get sentenced on the underlying felony as well. So I don't know what your thinking is.
Well, Your Honor, this is at the beginning, so I think we're going to have certain scrutiny over his payments going forward. Certainly, if there proves to be no payment in February, and then he has an additional problem of meeting at least the monthly obligation, I think we can certainly advance sentencing or look at probation violation and things along that line.
Well, that's what my thought is. If it's just an accounting issue, you could move for sentencing in a month or 2 months. We could proceed with the delayed sentencing today, and again, if it's an accounting issue where it's only getting credited once a month or whatever, at least the way it's going, your office could petition, and obviously Attorney Drake and Mr. Murray would be aware of the fact that I could proceed at any time during that delay to sentence him on the underlying charges. So did you want to proceed today then, or?
Yes, Your Honor, I think we would. I do remain skeptical about the accounting issue because all of the payments that we've been receiving multiple times a month were all wage assignments. So there's something unusual that happened in the month of February.
Okay.
But I would move then to proceed with the delay sentence at this point.
And that may be something you follow up on, Mr. Murray, to make sure that the employer is withholding properly, or and you probably would know that when you get your paycheck, whether or not they're withholding or not. So if it has something to do with the hours or the amount of time that you're working, make sure that you keep Attorney Drake apprised of that fact so that he can address it, okay? All right, it sounds like we're ready to go ahead and proceed with sentencing then. Why don't we go ahead and take comments, or let me find out, you've gone over the report, no additions or corrections, is that right?
Well, I did have one issue. I don't know how to categorize it, other than the victim impact statement that I was provided from Brandy Mitchell. In the very first sentence, when they ask how has the crime affected you, she says the child support, no. And then the rest of her victim impact statement is about domestic violence issues and other things. I think anything unrelated to the child support issue should be stricken. There's no prior history of any sort of domestic violence or anything, and I know that there's great latitude into what victims are able to say, but I think that it's a bridge too far to have the entire victim impact statement, except for I think 2 sections referencing, issues that were not, never alleged, and he hasn't, we're not here on any of those issues. He has one pending misdemeanor charge from South Bend on his record. Other than that, this is his only contact with the criminal justice system. So I think that should be stricken.
I'm gonna deny the request to strike anything. I think that when the court looks at sentencing, other issues, counseling, we could have a B&E, but impose something because someone has a substance abuse issue or those kinds of things. So I think it's relevant as to what the court would decide to do for sentencing. So with that, I'm going to go ahead and just deny the request, and I'll keep the victim impact in place as submitted by the victim. With that, then, anything further? Attorney Drake?
No other additions or corrections, Your Honor.
Mr. Murray, you had a chance to go over the report with your attorney? Well, any information that you saw needed to be changed or corrected? Okay. Mr. Pappen, then I'll take comments from your office. We'll hear from Attorney Drake, and then we'll give Mr. Murray an opportunity to make a statement.
Your Honor, there are two changes that I would like to address. One here involves the body of the report. I believe it's a typo, but since it involves a dollar amount, I think we should change this. What I'm looking at is on the CFA 284 on page 3.
Okay.
It reads at the top of the page, the current amount of the arrearage as of February 15, 2024, and it should read $6,418.69, not 89 cents. And since it involves a dollar amount, I think we should change it because it is inconsistent with another area in the report.
Okay, we'll make that change then to 6,418.69.
The substantive change that I'll advise the court of is related to PRV 6. It's currently scored, I believe, at 5 points. And what they would be looking at is the bond or the connection to the criminal justice system, most likely referring to the marijuana charge. But I will point out that the marijuana charge is after the current offense was alleged, so therefore that should actually be scored at a 0. That substantively changes the guideline range from 0 to 6 months to 0 to 3 months.
Okay, yeah, it looks like it was 2 days prior. Okay, I'll go ahead and make that change then on PRV 6 to 0. Reduce that to a PRV total 0, PRV level A, and a guideline range of 0 to 3.
Thank you, Your Honor. And just to confirm, is a Branda Melissa Mitchell in the courtroom?
Do we have a Miss Mitchell?
No.
No, she's not in the courtroom.
Thank you, Your Honor. And in terms of my comments, I would only point out 2 things. During the PSI interview or intake interview conducted on February 1st, 2024, the defendant is reported as saying that he tends to keep this child support paid, so I'm not in this courtroom again. And if again it turns out that no payments are in February, I am concerned about that. I would then point to the victim impact statement where Ms. Mitchell indicates that Stephen has never been consistent in paying child support, quitting or getting fired from multiple jobs to not have to pay the support. I believe he should be held accountable to help our children financially. And with that, I have no other comments, Your Honor.
I only had just a couple that might be corrections, and I guess I was going to inquire of Mr. Murray. Obviously, when we look at his employment record, it shows that he has it shows $15 weekly. I'm assuming those were hourly rates and not weekly rates. It shows that you were making at Camps Pallets $15 a week. I'm assuming it was $15 an hour. Yeah, so those are all hourly. And then on the one question on the addresses, you have children with 2 different women, correct?
Yes.
It shows that all 3 children reside at the same address, 413 Grant. Is that correct? Okay. I assume that they probably lived with their mothers?
Yeah.
Okay. Are there some that live in Graham Street here in Cass?
No.
Okay. Where do they reside?
Cass, Eversburg and Niles.
Okay. Which is the child that lives in Niles?
Clay Matthew.
Who's that?
Clay Murray.
Clay is in, And do you have two children that are 9?
Yeah.
Okay, but Clay lives in Niles?
Yeah.
Okay. And then the other 2 children now live in Edwardsburg?
Yeah.
Okay. And we'll just make that, because it looked like all 3 children reside in the same address, but I knew they had different mothers. Okay. Any additional comments, Mr. Pappen?
No, thank you, Your Honor.
All right, Attorney Drake.
You know, as the court was just going over his employment history, and the PSI does show that even if he was inconsistent, he, according to the information in the report that I received, he has made payments since 2015. He's currently employed. He has a withholding order. I would ask the court, you know, I don't know what happened in February, but the fact that he made, you know, consistent payments in December and January, leading up to February, he's still employed at Shawnee. It would be, you know, my concern, as I indicated earlier, would be that there would be something that was an issue beyond his control, if he's, you know, got a withholding order.
Yeah, I was concerned because it showed Shawnee that he was laid off it says end date of January of 2024. You're
Right.
saying you still work at Shawnee?
Yeah, well, I went back to work there.
When did you go back?
Last week.
So were you laid off in January?
Yeah.
Okay, and you went, so that might be the reason. If you were laid off, obviously there was no income withholding. So you're back.
Yeah,
Okay.
I know that factories do that weird thing where they lay people off for periods of time, and I don't know how that
Okay.
works.
So that may be some of the issue, Attorney Pappen. It looks like he may have been laid off for the month of January, and he went back to work last week, so.
Your Honor, I do understand that that could affect the wage assignment, but I want to be clear that the requirement is not that he be placed on a wage assignment, that he make sure that that minimum payment is paid regardless.
I understand that. I just, at least that maybe understands at least why we didn't show payment, but it is required as part of the plea agreement. All right. Go ahead.
Yeah. And I hear what, you know, the AG is saying, but again, I mean, whatever. I think that what the court indicated is the most sensible way to proceed forward. You know, if there's any non-payments, then the AG can file to accelerate the sentencing, and we can come back and terminate the delayed sentence, but can't squeeze blood from a stone. The employment is there, the withholding order is there, and you know, $18 an hour is more than $18 weekly, but that's still not, you know, living in the life of luxury. So, you know, Mr. Murray does show, at least since he's entered this plea, that he's been working. I'd ask the court to adopt the delayed sentencing agreement.
All right. Mr. Murray, anything you want to say on your own behalf?
No.
All right. Well, Mr. Murray, you pled guilty to felony non-support because of a wage of over $7,500 accrued in your child support. When I look at your employment history and the fact that you were to pay $158 a month of child support, I'm kind of appalled. You couldn't give your kids less than $40 a week to make sure they're properly taken care of? And I realize you might be through some hard times, but, you know, you got some kids here, it's $40 a week. You know, that's all they're asking you to do. Trust me, kids normally go through a heck of a lot more than $40 a week. So it's not that they're asking you to dig real deep. I see you have an outstanding warrant for possession of marijuana in St. Joe. And again, I have to address this with people, you're not the only one. Maybe if you weren't spending money on marijuana, you could give some money to your kids so that they can eat. So if you got an issue with marijuana, you know, you gotta say, hey, kids gotta eat. You know, courts aren't gonna look on you favorably and say, oh, I'm not paying my child support. Oh, but I'm getting arrested for marijuana. That means somehow you're getting marijuana. So that money needs to go to your kids and not to your marijuana addiction. So as a result, though, of your failing to pay child support, you now have a felony on your record. The Attorney General has given you the opportunity to get it reduced to a misdemeanor, which is a huge benefit for you. And I hope if you can get the arrearage paid off. I don't know whether or not you're going to be able to accomplish that, but he also gave you the opportunity that if you paid the arrearage down to $4,000 before the delayed sentencing, that he would even reduce it to an attempt, which reduces it to a 2-year issue. If it's not reduced, you'll be back here at the time of delayed sentencing on the original charge. So what'll happen is I'm going to give you the opportunity, I'm going to delay your sentence for a period of up to 11 months. But that gives you an opportunity to address those issues and take advantage of the plea agreement. It looks like you have your arrearage paid down right now somewhere around $6,400. You're 35 years old, you have no other criminal convictions on your record. And so I'm going to give you the opportunity, as the AG did, to keep a felony off your record. But while you are in delayed sentencing, I do expect, because you're on probation court, that you address that outstanding warrant in Indiana. So you need to contact those courts, make sure you get that taken care of, because I don't want to come back for sentencing and have you still have a pending criminal case. So contact them, see if you get that taken care of. And hopefully when you get your criminal record straightened out, your child support straightened around. And again, as the prosecutor indicated, I think as your attorney pointed out, I can't get blood out of a turnip or a rock, but try to do the best you can. If you are laid off, I'm assuming you got unemployment or something, and so some of that money needs to go to your children. Even if there's no income withholding order in place, if you're laid off, if you do receive unemployment or some kind of subpay of some kind, you need to make sure some of that goes towards your child support. Okay. So on the count 1 charge of felony non-support, I'm going to accept your plea for the record pursuant to statute. I'm going to delay your sentencing for a period of 11 months, give you the opportunity to prove your leniency here, give you the opportunity, obviously, to avoid having a felony on your record. I'm going to require you report to your investigating agent as he or she directs, comply with all verbal orders. During the term of your delay, I'm going to order that you pay a supervision fee of $300. I'm going to order you to serve 4 days Cass County Jail with credit for 4 days you've already served. I'm going to also order you to pay $68 in minimum state costs, crime victim rights assessment of $130, attorney fees of $350 to partially reimburse the cost of providing legal services in this matter, court costs of $500 if the court deems reasonable based on the average cost of prosecuting a case here in the county, or to pay a fine of $500. I'm going to advise you do have the right to appeal your sentence or conviction. Mr. Murray, have the deputy provide you with notice of your appellate right to review. Have you initial that, you'll receive copies. If you do wish to appeal your sentence or conviction, get that back to the court within 42 days of today's date. If you could not afford an attorney, the court would appoint an attorney to represent you at public expense. Anything further, Attorney Pappen?
Nothing further, Your Honor.
All right. Attorney Gray?
Nothing further, Your Honor.
Okay, and we've got the notices for the delay.
Yes.
We're going to have you come back in January 31st. Thank you, sir. At 8:30. That'll give you an opportunity, Mr. Murray, to hopefully get things taken care of so that we don't have any issues with you in the future. If you come back and you've got that arrearage paid on that date, or you probably close your case out, reduce the charges to a misdemeanor, and you'll be done with us, all right? All right. Anything further from you, sir?
Nothing, Your Honor.
Okay. Attorney Pappen, anything further?
Nothing further, Your Honor.
All right, we'll go ahead and stand adjourned.
Yeah, like I told you in the beginning, this judge, he gets mad when kids are affected by, especially by drug use. Yeah. If you've got money for drugs or alcohol, you dang well better have first had money for your kids. That's just all there is to it. Like, nothing should impact you trying to provide for your children. And if you're laid off, get a job in the interim. It may not be as, as nice of a job as what you had, but it's better than having nothing, isn't it? Maybe I'm wrong on that. Maybe that's just not how it is now. For me, I spent a lot of time in sales with commissions and all that other crap. Yeah. You darn well better. That's what the paw firm does. We lick the like button. Only Nicola Maxwell can't lick the like button because she said earlier that she got strep. And we don't want that passing around. I love you, Nicola Maxwell. I hope you're feeling good, honey. Getting some sleep. Yes. Oh my God. And they make good money most of the time. DoorDashers, Uber drivers, like there's no reason you can't, for the majority of the time. And at least it's something to provide for your kids, right?
Thank you.
We'll go back on record on the court's morning docket on Friday, March 1st. Who do we have in the jail?
Your Honor, it's Roberto Reno.
Okay, why don't we take Mr. Reno and then we can have them bring Mr. Martin up and then I can proceed.
Yeah, that would be Mr. Hoag's case, and I don't see him. I can go see if he's out.
Okay.
I do know, just for the record, I understand we're moving people through the jail, but Mr. Sopanos is available on Zoom whenever the court's prepared to call his case as well.
All right, we can call file 23-10070FH, People State of Michigan versus Harold Matthews. Attorney Ronning is here in that matter. Attorney Sopanos, are you on Zoom?
He was as of a few moments ago. Uh-oh.
Well, I guess if I don't hear the motion, he can be here Tuesday for trial.
I will try to call him again this morning to see what's going on. I see Mr. Matthews is on Zoom. I know he was on.
Attorney Drake, I see Ms. Phillips.
Yes.
We'll go on record and file 23-10230FH.
Your Honor, this is Dr. Panis. I understand you called my case. I'm back now.
Yep, I called your case, but I've called another one since. We'll get with you as soon as I'm done with Attorney Drake here.
Thank you.
All right. All right, we'll go on record and file 23-10185. FH, People State of Michigan versus Amanda Nicole Phillips. Are you Miss Phillips?
Yeah.
All right, Ms. Phillips, your attorney, Mr. Drake is present here in the courtroom in this matter, and Attorney Chastity is handling this matter. This matter is on the court's docket for a plea, and if there's an agreement, Attorney Chastity stated for the record, I'll confirm with Attorney Drake and his client.
Thank you. There is agreement that the defendant would plead guilty to count 1, and we would dismiss the habitual offender notice. In addition, there's a COPS agreement for a sentence of fines and costs.
Okay, Attorney Drake.
That's my understanding of the agreement, Your Honor.
Ms. Phillips, did you hear the agreement?
I did.
Now, you be pleading guilty to a charge of possession of methamphetamine that is a felony in the state of Michigan, does carry a maximum penalty of up to 10 years incarceration or a fine of up to $15,000. You understand that?
Yes, sir.
Counsel met with the court yesterday. I looked at you, reviewed your prior record. Court did agree that based on the this offense and your record, that the court would impose a sentencing agreement of fines and costs in this matter at the time of sentencing. You understand that?
Yes, sir.
You understand that there will be a requirement of a pre-sentence investigation report, and so as long as everything is consistent with what was represented to the court yesterday, the court will follow that agreement. If there's anything else additional on your record that I was not notified of, or you violate the law or any terms or conditions of your bond, that the court could bring you back on that date and sentence you on the underlying offense based on the guidelines that are prepared in the report. You understand that? And understanding that, you still want to go ahead and enter your plea here today? Okay, can you raise your right hand? Can you raise your right hand? Yeah. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in this matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. Is your name Amanda Nicole Phillips?
Yes, sir.
You can put your hand down if you choose. What's your date of birth, Miss Phillips?
9/16 of 80.
Okay, now if I accept your plea here today, you're giving up all right to have a trial, and that includes the right to have a trial by a jury. You understand that?
Yes, sir.
Giving up the right as well to be presumed innocent at that trial till proven guilty by the prosecutor, be giving up the right to require they prove your guilt beyond a reasonable doubt. You understand that?
Yes, sir.
Also giving up the right to have the witnesses who accuse you of these charges to actually appear in court, testify under oath in front of you and your attorney. Be giving up the right as well to have your attorney question or cross-examine those witnesses. You understand that?
Yes, sir.
You're also giving up the right to present witnesses or evidence in your defense and at the request of attorney Drake to have the court issue subpoenas on your behalf so that you would have that opportunity. Do you understand you're giving that right up?
Yes, sir.
You are giving up the right as well to remain silent in these proceedings and not have your silence used against you. Do you understand that?
Yes, sir.
And you're giving up the right as well to testify at that trial on your own behalf if you wish to testify. Do you understand that?
Yes, sir.
When you plead guilty, Ms. Phelps, I want you to understand as well that you're giving up certain appellate rights. That means you cannot appeal your conviction as of right, but you can still appeal it by filing an application for leave to appeal, and the issues you can appeal on are limited. So I want you to understand by pleading, you are giving up some of your appellate rights. Do you understand that?
Yes, sir.
Let me ask you, Ms. Phillips, other than the agreement that was stated on the record and confirmed by your attorney, which you confirmed with me, other than that agreement, has anybody promised you anything?
No, sir.
Is anybody threatening you in any way?
No, sir.
Are you pleading guilty to that charge of possession of methamphetamine of your own free will because you believe you're guilty?
Yes, sir.
All right, I'm going to read that charge to you. It alleges on or about July 19, 2023, in the city of Dowagiac here in Cass, you did knowingly or intentionally possess methamphetamine. Is that true?
Yes, sir.
Tell me what happened on that date.
I was at Dollar General. I was getting some stuff out of the dumpster. I come across a purse. I pulled the purse out. Cops came by and asked what was going on. I told them basically I was dumpster diving. They wanted to go through the purse and stuff, and I let them, and they pulled out a bag of meth and the rest of me in the jail. And so that's all that happened there.
Okay, so you were in possession then of methamphetamine on that July 19th date, is that correct?
Yes.
Satisfied, Attorney Drake?
Satisfied, Your Honor.
Attorney Chassie?
Yes, Your Honor, satisfied.
Let me ask you then, after that, count one charge on about July 19, 2023, in the city of Dowagiac here in Cass County, you knowingly or intentionally possess methamphetamine. How do you plead to that charge?
Yes, sir.
Okay, I'm going to accept your plea, find it's voluntarily and understandably made, maybe with the assistance of your attorney, Mr. Drake. I'm going to set your sentencing, Ms. Phillips, for Friday, April 19th at 8:30 in the morning. In the meantime, you'll need to contact the probation department and set up an appointment and get a pre-sentence investigation report completed. If you fail to appear for sentencing or get the report completed, that would also be a violation and would affect the agreement that we made here today for fines and costs. You understand that?
Yes, sir.
All right. Anything further from the people?
No, Your Honor.
Attorney Drake?
Nothing, Your Honor.
Ms. Phillips, any questions before sentencing?
Sure.
Okay, we'll go ahead and adjourn. You can sign off. Next matter we'll call is file 23-10070FH, People State Michigan versus Harold Matthews. Attorney Sopanos is here, and I believe this is a motion that was filed by you, Mr. Sopanos. We are scheduled for trial next Tuesday with Mr. Matthews. I see Mr. Matthews there on the screen. Can you hear me, Mr. Matthews?
Yes, sir.
All right. Attorney Ronning is here on behalf of the people. Attorney Spanos.
Thank you and good morning, Your Honor. I'm asking for a adjournment in this matter for a variety of reasons. First and foremost, and I have discussed this matter with the prosecuting attorney's office, Mr. Ronning, who's in the courtroom. He has no objection. I've also reached out to the attorney representing Mr. Matthews in Indiana to see where that case is, Your Honor. That attorney has suffered a loss in his family and has been unavailable. I've talked to the authorities in this matter. I have not sat on my thumbs. Mr. Ronning and I believe we can work out a plea agreement. We are just kind of hamstrung by what's going on in Indiana, Your Honor. It's my understanding that you previously adjourned this matter prior to my involvement in hopes that Indiana would have already resolved their end of it, because the charges there, Your Honor, from my understanding and belief, are much more serious and will probably carry a much greater penalty. I think Mr. Ronning would agree, and I've talked to the authorities, and what we're trying to do, Your Honor, is not waste your trial date. We're trying to coordinate, and in the long run, I do not believe this is going to be a case that's going to need a trial. What I'm saying is I think Indiana will be dispositive of this case. Mr. Ronning, would you agree?
Why is this the second defendant that has charges in Indiana? And not only does he have charges in Indiana, the charges that he has in Indiana are far greater than the ones that he has here in Michigan. Like, does everybody in Indiana who commits a serious offense migrate to Michigan? That's what I want to know.
I would, Your Honor. I would indicate for the record, I've spoken to the assistant prosecutor in Elkhart County multiple times on this matter. There are substantially more serious charges in Indiana, although their sentencings are quite different. It was our hope that that would have been resolved. It had been up for trial, but I believe the court called an in-custody sexual assault charge instead. I know Mr. Spanos has just recently come onto the case. I do agree that I think there is a resolution in play here. I think I do also recognize this has been adjourned once with the prior attorney for that very reason. I would say that we do not object to this adjournment, again, to avoid what could be not a super long, but I think there's some benefit.
Mr. Ronning, I'm sorry, the phone cut out. Were you done? I apologize.
No, I was just going to say that I think that if this were I think this would be the last adjournment we would agree to for this particular reason. And then if we can't resolve it, if Indiana doesn't resolve, then we are prepared to go forward. But I think there is some benefit in trying to combine these two cases.
All right.
Your Honor, one additional fact, Your Honor, that I forgot to tell you. Really, this cannot be blamed on Mr. Matthews. I think Mr. Ronning knows this too. That is that the only reason he had to find a new attorney at the last minute, Your Honor, was because his former attorney, Mr. Nord's law firm, went out of business, and he went back to the Kalamazoo County Prosecutor's Office and kind of left Mr. Matthews out in the wind. So Mr. Matthews immediately started looking for other attorneys. There was no drag time, Your Honor. So I also thought that it would be beneficial for you to know that, and I think Jason can tell you the same thing.
I can confirm that.
Okay. Well, this is the second request for adjournment. I think the first request came actually from Attorney Fitz. Prosecutor Fitz came to my office and requested an adjournment. It is the first request, I believe, and not that it wasn't a joint request, but understand that Attorney Norg, obviously Mr. Matthews, prior attorney, has gone to the prosecutor's office in Kansas County, and I guess be fair to assume, Mr. Spanos, that Mr. Matthews doesn't want a prosecutor representing him at his trial?
That would be a very astute comment, Your Honor.
Okay, I'll go ahead and grant your motion to adjourn then. If you could just submit a short order indicating it'll be adjourned to a date to be set by the court, we'll get the matter rescheduled. How much time do you think you'll need to get it rescheduled? And the only reason I ask is I know the felony information was filed in this case in March of last year, so, you know, the Supreme Court keeps track of us and wants us to get things done within a year. I understand. I'm not in a you know, have any big issues going on because of what happened with the council. But how long do you think you'd need to get it set out if I get it reset out? 90 days? Does that work for you, Attorney Spanos?
Yes, yes, Your Honor, thank you.
Okay, we'll try to get her set out there within 90 days. Mr. Matthews, you stay in contact with Attorney Spanos, so we'll get your trial rescheduled, all right?
Yep.
All right, we'll go ahead and adjourn then in this matter.
Thank you.
You're welcome. And who did we have in jail?
That's Mr. Rainey, Your Honor.
Mr. Rainier?
Yes, Your Honor.
Okay. Attorney Hogue then?
Yes.
We'll go on record and file 23-10180. People say Mr. and Mrs. Robert Ramiro Rainier. Attorney Hogue is here on behalf of Mr. Rainier. Mr. Rainier is in court, and I do have, who's handling this? Attorney Ronning. Attorney Ronning's here on behalf of people. I do have a letter of recommendation for Mr. Rainier for Swift Insure. So is this matter set for plea?
This is set for plea, Your Honor, yes.
All right. Attorney Ronning, then, if you would state the agreement for the record, I'll confirm it with counsel and Mr. Rainier.
Yeah. And there's the people's understanding that the defendant will be pleading guilty to count 1 and 3 of the felony information, pursuant to agreement that people will be dismissing the remaining counts. That plea would be entered as a habitual offender 3rd. So it's currently charged, I believe, as a 4th. It will be entered as a habitual offender 3rd. Also with the understanding that the people would not be objecting to Mr. Rainier being sentenced into the Swift Insure program, which he's been recently approved for. One other remaining portion of it, Your Honor, is that Mr. Rainier does have a pending misdemeanor case that is filed 23-1037-SM. That was a larceny case. That case will be dismissed as a part of this agreement if the defendant does agree to pay any restitution that is requested on that case, and we would be handling that in this court on the felony charges to see if there's any restitution required on that larceny case. So that would be a portion of it as well.
Okay, that case isn't in circuit yet.
It is a misdemeanor. It will stay in district court.
You're just going to dismiss that as part of the agreement if
Exactly
there's
right.
restitution.
That's correct. Your
Okay.
Honor. Yep.
All right, Attorney Hogue.
That's a correct statement of the offer, and I did review this with Mr. Rainier, and he has indicated he wishes to take advantage of this offer.
Mr. Rainier, then, is that the case? You want to take advantage of this agreement?
Yes, sir.
Can you raise your right hand?
Yes, sir.
Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in this matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can put your hand down. Is your name Robert Ramiro Rainier?
Roberto Ramiro Reina.
I'm sorry, Roberto Ramiro Rainier?
Yes, sir.
Okay, what's your date of birth, Mr. Rainier?
7/28.
Now, Mr. Rainier, that count 1 charge you'd be pleading guilty to is a charge of possession of methamphetamine. It is a charge, carries a maximum penalty of up to 10 years and or a fine of up to $15,000. As an habitual 3rd, that doubles that penalty to a maximum term of up to 20 years. You understand that?
Yes, Your Honor.
The count 3 charge, the resisting and obstructing a police officer, is a felony, carries a maximum penalty of up to 2 years and or a fine of up to $2,000. As an habitual 3rd, that would double those penalties to up to 4 years in the state's prison. You understand that?
Yes, Your Honor.
Okay. Understanding the nature of those charges, as an habitual 3rd offender, do you want to plead guilty to those 2 charges in exchange for the agreement of the prosecutor to dismiss the remaining charges in the account, in the felony information?
Yes, Your Honor.
Okay, you understand as well that part of the agreement is that there is a misdemeanor case in district court that they will agree to dismiss as long as you agree to pay restitution in that matter. You understand that?
Yes, Your Honor.
And then there will also be an agreement that you will participate in the Swift Insure program. The prosecutor would have no objection to that. You understand that?
Yes, Your Honor.
Okay. You want to go ahead and take advantage of that agreement then?
Yes, I do.
All right, Mr. Rainey, if I accept your plea, I want you to understand that you'll have no trial in this matter, and that includes the right to have a trial by a jury. You understand that?
Your Honor.
You'll also be giving up the right at that trial to be presumed innocent until proven guilty of those charges by the prosecutor beyond a reasonable doubt. You understand you're giving up those rights?
Yes, I do, Your Honor.
You'll be giving up the right as well to have the witnesses who accuse you of the charges appear in court, testify under oath in front of your attorney, Mr. Hogue, giving up the right to have Attorney Hogue question or cross-examine those witnesses. You understand that?
Yes, I do.
Giving up the right as well to have the court subpoena witnesses or other evidence into court for your defense at the request of Attorney Hogue in this matter. You understand you're giving up the right to have the court assist you in that regard?
Yes, I do.
You're also giving up the right to remain silent in these proceedings and not have that silence used against you at a trial in this matter. You understand you're giving up those rights?
Yes, I do.
Mr. Rainey, you're giving up certain appellate rights as well. By pleading here today, you can still appeal your sentence or conviction, but to do so, it requires the filing of an application for leave to appeal. There's no automatic right to appeal your conviction when you enter a plea, and the issues you can appeal on are limited. So do you understand you are giving up some of your appellate rights?
Yes, I do.
All right. Let me ask you, other than the agreement that we've gone over on the record here, which you've confirmed with the court yourself, has anybody promised you anything?
No, sir.
Anybody threatening you in any way?
No.
Pleading guilty to these two charges of your own free will because you believe you're guilty of those charges?
Yes, I do, Your Honor.
Any other terms and conditions I know that we didn't go over?
No, Your Honor.
Attorney Hogue?
No, Your Honor, everything has been placed in the record.
All right. I'm going to take you back then to July 11th of last year, Mr. Rainey. It says the offense in count 1 alleges on July 11th, 2023, that you were in the city of Dowagiac here in Cass County, and in count 1, you did knowingly or intentionally possess methamphetamine, and in the count 3, that on that same date and location, you did assault, batter, wound, resist, obstruct, oppose, or endanger Kevin Roman, a police officer that you knew or had reason to know was performing his or her duties, contrary to Michigan statute. So, were you involved in a confrontation or have some contact with a Dowagiac police officer in the city of Dowagiac on July 11th of last year?
Yes, I did, Your Honor.
Okay, and I'm assuming at that time that you were in possession of methamphetamine. Is that correct?
Yes, I did, Your Honor.
Okay, tell me what happened in the incident. How did the incident happen? I mean, did the officer stop you in a car? Were you on the street? Were you at home? Where did it happen?
I was in my vehicle and I seen the cop behind me, and we pulled over and got out and started walking, and pulled up on us and asked us to search us and asked if we was in the car. And by then he had told me to cuff up, and I didn't comply at first. And then after they proceeded to search the car, they found methamphetamine in the backpack.
Okay, and that was your backpack, and you knew that it was methamphetamine and a legal controlled substance?
Yes, Your Honor.
Okay. Satisfied, Attorney Ronnie?
People are satisfied, Your Honor?
Attorney Hogue?
Yes, Your Honor, thank you.
Okay. Let me ask you then, Mr. Rainey, as to that count 1 charge on or about July 11th, 2023, city of Dowagiac, Cass County, you did knowingly or intentionally possess methamphetamine. How do you plead to that charge?
Guilty, Your Honor.
And the count 3 charge on or about July 11th, 2023, in the city of Dowagiac, Cass County, you did assault, batter, wound, resist, obstruct, oppose, or endanger Kevin Roman, a police officer that you knew or had reason to know was performing his or her duties contrary to Michigan statute. How do you plead to that charge?
Guilty, Your Honor.
Okay. And let me just follow up. I'm assuming that Mr. Roman was in a marked police vehicle and in a police uniform?
Yes, Your Honor.
And so you knew he was an officer?
Yes, I did.
All right. Ask you a couple questions about the habitual offender statute. It does say that on or about July 29th of 2016, you were convicted of 2 separate counts of possession of methamphetamines, as well as a conviction for the possession of analogs. Is that true?
Yes, Your Honor.
And in those matters, did you plead guilty?
Yes, I did, Your Honor.
Okay. And what happened in those matters? Did you do probation, jail? What happened?
I did a little bit of jail time, Your Honor, and I did probation and completed it successfully.
Okay. Court is satisfied then, there is a basis for accepting the pleas here as an habitual third. I'm gonna go ahead and set your case for sentencing on March 22nd at 8:30. And in the meantime, there will be an agent who will be in contact with you and prepare a pre-sentence investigation report. Anything further from the
Nothing
people?
further, Your Honor. Thank you.
Attorney Hogue?
Your Honor, I am going to request a PR bond for Mr. Reyna. He is currently been incarcerated roughly nearly about 8 months. I know the sentencing set for later on this month. I would just request the court to take that in consideration. He does have stable living arrangements with his mother, who lives in Dowagiac, so I just request the court to take that in consideration.
Okay, well, okay, I'm gonna deny the request at this time only because obviously it's Swift and Sure, I'm assuming there are some high guidelines. I've not seen, what his, record is. Again, we're set pretty quick. If you wanna bring a motion and so that I can have all that information, I will review it. But until I've had a chance to review that prior record and review all the information, we'll go ahead and, just deny the request. But I will, pending sentencing, if you wanna bring a motion, we'll review that, okay?
Thank you, Your Honor.
All right.
It always amazes me when they ask for a PR bond when it's, felony offenses and things like that. For real, dude? Like, or when they're facing charges in multiple states and they've absconded how many times? And it's, the prosecution is asking for no bond hold or $100,000, and defense is like, can we get a PR bond with that? They've got steel cojones the size of basketballs, I swear.
Mr. Rainey, do you have any questions for the court before we adjourn?
No, Your Honor.
Okay, Attorney Feldman, I know you want a breakout room with him. How long are you gonna need?
But Mr. Martin, 5 to 10 minutes, Judge.
Okay.
I'll bring Mr. Martin here shortly.
All right. Put Attorney Feldman in a breakout room with Mr. Martin, and we'll take a short recess.
Thank you, Judge.
Court is in recess. We'll go back on record in file 23-10124 FC, People Save Michigan versus Cordelis Martin. Mr. Martin is present via Zoom from the jail. Can you hear me, Mr. Martin?
Yes, sir.
Okay. Your attorney, Mr. Feldman, is here in the courtroom along with, from the prosecutor's office, Assistant Prosecutor Attorney Jason Ronning. This matter is on the court's docket. I'm showing for a plea, and if there's an agreement, turn around and have you state that for the record.
Thank you, Your Honor. Your Honor, we believe there is an agreement in this case. It's the people's understanding that the defendant will be entering a plea of guilty to count 2, assault with intent to rob while armed. Pursuant to the agreement, the people will be moving to dismiss the remaining counts and the remaining notices. There is a Killebrew agreement in this matter, Your Honor. The defendant's sentence agreement would be for 7 years, Department of Corrections.
Attorney Feldman.
That's a correct statement of the plea, Your Honor. I have gone over that with Mr. Martin earlier this week and then again this morning.
All right. Mr. Martin, you heard the agreement. Do you want to go ahead and take advantage of that agreement?
Yes, sir. I believe that's the only choice I have right now.
Okay. Well, I don't know if it's the only choice. Your choice is we do have the matter scheduled for trial. You do have the right to have a trial in this matter. So if you don't want to plead today, I don't want you to feel forced into it. If you feel that you don't want to enter the plea today pursuant to the agreement, let me know that, and I won't go forward with the plea.
Yes, sir. I accept the plea.
Okay. Can you raise your hand? Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in this matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can put your hand down, sir. Is your name Cordelis Anthony Martin?
Yes, sir.
And Mr. Martin, what's your date of birth? Now, Mr. Martin, the charge that you'd be pleading to is the count 2 charge, is a charge that alleges on or about July 27th of 2023 in the village of Cassopolis. here in Cass County that you did make an assault upon Prince Singh with the intent to rob and steal while being armed with a dangerous weapon, or an article used or fashioned in a manner to lead the person so assaulted to reasonably believe it to be a dangerous weapon, to it a knife. And that is a charge that does carry a maximum penalty of up to life in prison or any term of years. You understand the nature of that charge?
Yes, Your Honor.
And understanding that, you wish to enter your plea to that charge?
Yes, Your Honor.
Prosecutors agreed to dismiss the remaining charges and the offense notices with an agreement that you would serve a minimum sentence of 7 years. Is that your understanding of the agreement?
Yes, Your Honor.
All right. And with that, you want to go ahead and accept that agreement?
Yes, Your Honor.
Now, if I accept your plea here today, I want you to understand you are giving up the right to have a trial, and that includes the right to have a trial before a jury. You understand that?
Yes, sir, Your Honor.
You'd be giving up the right as well to be presumed innocent at that trial until proven guilty by the prosecutor. You'd be giving up the right to require that they prove your guilt at a trial beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You'll be giving up the right to have the witnesses who accuse you of the charges to actually appear in court, testify under oath in front of you, and your attorney, Mr. Feldman, be giving up all right to have Attorney Feldman question or cross-examine those witnesses. You understand that?
Yes, sir, Your Honor.
You'll also be giving up the right to present witnesses or evidence in your defense and to have the court issue subpoenas so that you would have that opportunity. Attorney Feldman could subpoena witnesses or evidence. He could request the court as well to issue subpoenas on your behalf if need be. Do you understand you're giving up the right to have the court assist you and your attorney, Mr. Feldman, by issuing subpoenas on your behalf?
Yes, sir, Your Honor.
You're also giving up the right to remain silent and the right that you would have at trial to remain silent and not have that silence used against you. Do you understand you're giving up that right here today?
Yes, sir.
And you're also giving up the right you would have to testify at that trial. Do you understand that?
Yes, sir.
In addition, I want you to understand you are giving up some of your appellate rights, Mr. Martin. When you do plead guilty, you can still appeal your sentence or conviction, but because it's a plea, the issues are limited. And there's no automatic right to appeal, but if there are some issues with the plea-taking process, you can file an appeal and appeal your sentence or conviction. So do you understand you are giving up some of your appellate rights by pleading here today?
Yes, sir.
And then you're also giving up the right to later come back and ask that I set aside your plea because of a promise or threat that's been made to you that you've not told me about here today on the record. Do you understand that?
Yes, sir.
Let me ask you, Mr. Martin, other than the agreement that was stated on the record, which prosecutor stated, confirmed by your attorney, Mr. Feldman, and which you confirmed with me here on the record, other than that agreement, has anybody promised you anything?
No, sir.
Is anybody threatening you in any way to get you to plead here today?
No, sir.
Are you pleading guilty then to that charge of your own free will because you believe you're guilty?
Yes, sir.
All right. Take you back to July 27th of last year. Were you here in the village of Cassopolis on that date?
Yes, sir.
Did you make an assault upon a Prince Singh with the intent to rob? And what that means is, did you go, I believe you went into the convenience store there to rob the store, is that correct?
Yes, sir.
And were you armed with a dangerous weapon, a knife?
Yes, sir.
Okay, and you used that article to make an assault upon Mr. Singh and ask him to give you money, is that correct?
Yes, sir.
Okay. Anything further?
People are satisfied, Your Honor.
You have a factual basis on the elements, Your Honor.
All right. Let me ask you then, Mr. Martin, as to that count 2 charge on or about July 27th, 2023 in the village of Cassopolis here in Cass County, that you did make an assault upon Prince Singh with the intent to rob and steal while being armed with a dangerous weapon or a weapon that was used or fashioned in a manner to lead the person so assaulted to reason to believe it was a dangerous weapon, to it was a knife. How do you plead to that charge?
Guilty.
Okay, I will accept the plea, find it is voluntarily and understandably made with the assistance of your attorney. Mr. Feldman, as you've indicated that there are no threats or promises other than the agreement that was stated on the record. I'm going to set your case for sentencing on, is that March 5th or April 5th? April 5th at 8:30 in the morning. In the meantime, a probation agent will be over to discuss the matter with you and prepare a report for the court. Does court comply with the court rules?
Court has complied, Your Honor.
Attorney Feldman?
You have, Your Honor.
Anything further from counsel?
Nothing further, Your Honor.
Mr. Martin, do you have any questions for the court? All right, we'll go ahead and stand adjourned then. That concludes the court's morning docket on Friday, March 1st.
Thank you.
All rise. The court will stand in recess.
And that was all she wrote for that docket. That was the whole darn thing. I know that was long. I know it was long. But every once in a while, I'm going to do these for a good reason. I want to give people something that they can put on in the background and wash their dishes, clean their house, play with their animals, do whatever, and leave it on in the background. Hit the like button first, please. It's my way of, because there's not a lot of visual stuff going on in that courtroom, So, but the cases were really good. So it was just my way of giving something. Whoops. I meant to click on this one. 5 hours. I did that 7-hour one that one time. And then I had some guy in the comment complain that I did a 7-hour stream because who wants to watch a 7-hour show? I was like, so I don't know, watch an hour of it and then turn it off, maybe? I don't know. Do what you want. Other people were really happy with it. Oh, you can't please everybody. Yes, lots of licks. Lots of licks. Oh, I can't go to bed yet because my bed has a couple of packages on it. And I don't know what they are yet. I really don't. But Kendra saw them and she goes, "What are those?" And I was like, "I don't know yet. They're gifts." She's like, "For who?" I don't know, Kendra. Haven't opened them yet. So I gotta open them. I have to say, so y'all got her those roller skates for Christmas. She loves them. Yesterday was her best friend's birthday, and her best friend went to the skating rink, and Kendra's like, "I don't have to rent skates." And she got all excited and she wore them. She loves them, you guys. Thank you so much. Y'all, all of you guys have gone out of your way to make her happy in one way or another. And I'm so grateful. I really am. When I first started doing YouTube, she was embarrassed. She didn't like it. Like, nope, Mom, you're not that cool. She just thought that I was going to just embarrass her like parents are supposed to do. And now she's excited. Now she sees how much work I put into the channel. And even though it's not her thing, like she'd never watch one of my streams, even though it's not her thing, she has a lot of respect for it. And it's really all I can ask for from her. So that was really cool. She's too much. She's great, though. I love her. She's just special. And I don't think she fell on her butt either. Yeah, she was so happy. All right. I don't know who these are from yet. Okay. Someone that sent me something had messaged me and told me I had something coming and that I didn't have to open it on stream. The problem is 2 things came at once, so I don't know which one was theirs. So I have to open it on stream. Oh my gosh. You know what's funny? It's Kendra's favorite. Thank you so much, crazy old lady. I love you. And I am so grateful for you. And I'm sure Kendra is too. You are just too sweet. You really are. And I honestly, I don't know what I would do without you guys. All of you. And my mods. Tammy, Emily, Shane, Philip. Oh my God. I love you guys so much. That's just so funny. She's going to be so thrilled. She is. Okay, and this one scares me. It does. It's got the battery sticker on it. Whatever it has batteries in it. And I don't think I have anything on my list that has batteries. Okay. Oh, and I'm going to take the advice. I can't remember who said it. Someone teased me when I was trying to open a box at one time and said something about getting April a box cutter. April's got a box cutter. It's a Tropicana, world's largest producer of citrus products. Box cutter. Okay, here we go. Okay, I should probably cut away from myself. Things I learned working in restaurants. Hey, that went really smooth. I didn't even have to fight that. All right, here we go. Dun, 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 dun. Hold on. I got a new boa. Oh my goodness. on earth did this? Oh my God, I love you. Oh, you're gonna make me freaking cry. Okay, so this is a sleep mask for Kendra so that she can sleep and not hear me stream or the cats meowing outside her door. And it's Bluetooth, it plays music. A huge pack of kitty treats. I have no idea what these are. They say pillow roller. Oh, they're for curling her hair. And then Ava is gonna be so happy. Thank you so much. I love you. I can't help it. I can't help it. That was just... I am so blessed. I am so absolutely blessed. All I do is sit here and make videos and hang out with you guys. And you guys, you make me happy just to have friends like you. And then when life just crashes, you guys are there for me. I would not have been able to go see my mom for those 2 weeks every day. Well, not every day, but practically felt like it. A 2-hour trip there and 2-hour trip back every time. I wouldn't have been able to do that without you guys. And and my kid, her being happy is everything to me. It was, I am just, she's gonna love them. I don't even want to give her one yet. She's been so spoiled with treats all night, and she's sleeping. Well, now she's not. But if I give her one, she's going to be up all night. And then she's going to wake me up at, well, it's already 3 a.m. But she's going to wake me up to take her out to pee. She does that now. She also wakes me up to remind me to feed her. Thank you. I know you guys do. And it's hard because I've never had people in my life like this. And I still have days where, you get those thoughts that come through your head and you're like, do people actually like me? Or do they just put up with me, you know? Or do they just feel sorry for me, you know? And it's a pity friendship, you know? When you grow up having no friends and being shunned from family and things like that, you know, it leaves a mark. And it's hard to get over that. I know you guys love me. I know you do. And I promise you that I love every one of you. Pot meat kettle. That's the pot calling the kettle black right there. I know. I knew that was coming. That elusive, magical thing. It's like a unicorn. But I do need to go find it. I also need to blow my nose. I hate that it doesn't let me see the emoji. I love you so much. I'm damaged goods. I always say we're all broken here in one way or another. We're all broken crayons. But broken crayons can still color pretty pictures. Ah! Yep, the software hates the hand heart. You got up to pee, didn't you? Everybody does that. They get up to pee and then they check to see if I'm live. Whereas people in court? People in court has not had to pee yet. Oh, okay. But I am gonna go. I love you guys so much. Thank you. Thank you. Thank you. Thank you. Oh, wait. I forgot to do this. Hi, dolphins. All right, guys. Thank you so much. Be safe. Be well. Sleep sweet and much love.